in 1967 when measured relative to the advances made by other states in the region. 9. Moreover, the decades-long occupation constituted no fiscal burden on the Israeli treasury. On the contrary, Palestinians contribute large sums to Israeli public expenditure, what Meron Benvenisti, a leading Israeli authority on the occupied territories, dubbed an occupation tax. This net surplus extracted from the Palestinians, Benvenisti continued, refutes Israeli claims that the low level of public expenditure and investment in the occupied territories derives from budgetary limitations. If net fiscal transfers had been invested in the area, rather than added to Israeli public expenditure, it would have been possible to improve local services significantly, and in particular, to develop local economic infrastructure. 10. Since the outbreak of the new Intifada, the occupied territories have verged, according to a United Nations study, on a humanitarian catastrophe. 11. An in-depth World Bank report presented these grim statistics: GDP, gross domestic product, and GNI, gross national income, per capita shrunk respectively by 40 and 45% between 1999 and 2002. Unemployment hovers around 40%, while 60% of the population is living under the poverty line of $2.10 per day. Food consumption has fallen by 25% since 1998, and the prevalence of acute malnutrition recently observed in Gaza, 13.3%, constitutes an emergency with serious long-term implications for Palestinian health and development. A total collapse of Palestinian society has been averted only due to emergency budget subsidies from donor countries, mostly the Arab League and, less so, the European Union, as well as the resourcefulness and mutual support of Palestinians themselves. Regarding the latter, the normally unsentimental World Bank observes, Palestinian society has displayed great cohesion and resilience. Despite violence, economic hardship, and the daily frustrations of living under curfew and closure, lending and sharing are widespread and families for the most part remain functional. Even with a dearth of formal safety nets, outright destitution is still limited. Those who have income generally share it with those who do not. The West Bank and Gaza have absorbed levels of unemployment that would have torn the social fabric in many other societies. It goes on to deem this achievement quite remarkable. Given the repeated attacks on the United Nations Relief and Works Agency, UNRWA, which is the second largest provider of social services in the occupied territories after the Palestinian Authority and is responsible for delivering health, schooling, and humanitarian assistance to refugees, half the total population and over 70% of Gazans, it also merits quoting the World Bank's observation that UNRWA's emergency programs continue to be held in high regard by the population. 12. The proximate cause of the Palestinian economic crisis, according to the World Bank, is closure, that is, the restrictions Israel has imposed on the movement of Palestinian goods and people across borders and within the occupied territories, and the sine qua non of economic stabilization is a significant easing of the current regime of internal closures and curfews, and the granting of easy access to external markets. 13. An Amnesty International study assessing the impact of Israel's closure and curfew policies on Palestinians reported that its impact on their right to work and to an adequate standard of living, education, and health care has been devastating. Among its endings were these: some villages have been completely sealed off and urban areas are frequently placed under 24-hour curfew, during which no one is allowed to leave the house, often for prolonged periods. Trips of a few kilometers, where they are possible, take hours. Following lengthy detours to avoid the area surrounding Israeli settlements and settlers' roads, by the year 2000 most of the 1.3 million Palestinians living in Gaza had never left the Gaza Strip, an area totaling a mere 348 square kilometers. The main roads of the West Bank are for Israeli cars, clearly identifiable by yellow number plates, and military vehicles. Palestinian vehicles, distinguishable by their green license plates, are prohibited. In recent years, Amnesty International delegates have rarely seen a green-plated car on main roads, apart from a few shared taxis. Palestinians have often been in carts pulled by donkeys or mules, a rare sight 3 years ago, after the Israeli army retook control of the 6 main West Bank towns. In March, April 2002, 24-hour curfews were enforced for days and in some cases weeks. Civilians were conned to their homes and movement outside was prohibited. Bethlehem was under curfew for 40 consecutive days. Nablus remained under 24-hour curfew for months after June 21, 2002, apart from 1 month when it was under a night curfew only. Palestinian vehicles and passengers in Gaza have been stuck between checkpoints for hours, unable even to get out of their cars for fear of being shot. Closures and curfews are controlled by military force. Members of the Israeli security forces have frequently resorted to lethal force to enforce restrictions, killing or injuring scores of Palestinians who were unarmed and presented no threat. Soldiers opened on Palestinians bypassing checkpoints, crossing trenches, removing barriers and breaking curfews. 14 While strongly affirming that Israeli authorities have not only a right but a duty to take necessary measures to protect Israelis, Amnesty goes on to point out that the increasingly sweeping and stringent restrictions imposed indiscriminately on all Palestinians have not put a stop to the attacks. On the contrary, attacks intensified as restrictions on the movements of Palestinians increased, calling into question the effectiveness of indiscriminate restrictions that treat every Palestinian as a security threat and punish entire communities for the crimes committed by a few people. In addition, it notes the frequent arbitrariness of internal closures, the fact that soldiers enjoy broad, individual discretion to permit or prevent Palestinians' movement undermines the Israeli authorities' contention that the internal closure is a rational system of control, based strictly on security needs. Indeed, Amnesty questions altogether the legitimacy of internal closure. Insofar as its relationship to Israeli security is highly dubious, it is important to differentiate between restrictions on Palestinian movement from the occupied territories into Israel, and movement restrictions within the occupied territories. Movement restrictions may be necessary to prevent attackers entering Israel and carrying out suicide bombings and other attacks. However, it cannot be said that preventing or restricting the movement of Palestinians between Ramallah and Nablus is necessary to prevent attackers from entering Israel to carry out an attack in Jerusalem or Tel Aviv. Yet closures and curfews are often justified on these grounds and are routinely imposed or tightened following Palestinian attacks inside Israel. Like the bombardments of Palestinian Authority buildings which usually follow Palestinian suicide bombings or other attacks, closures and curfews often appear to be intended more as punishment or retaliation for attacks by Palestinians, both inside Israel and against Israeli settlers or soldiers in the occupied territories, as well as to show the Israeli public that the army is taking action. This is particularly obvious in the Gaza Strip, where Palestinians have rarely succeeded in crossing the surrounding electric fence into Israel. None of those who have carried out attacks inside Israel in recent years are known to have come from the Gaza Strip. Yet, in the wake of every major Palestinian attack inside Israel, the Israeli army usually attacks installations in Gaza, such as the airport, the seaport, or police stations, most of which have been bombed several times. 15. Apart from preventing attacks on Israel proper, the main Israeli justification for closure is protecting illegal Jewish settlers. Even though only a very small percentage of Palestinians have been engaged in attacks against Israeli settlers or soldiers, every Palestinian is regarded as a potential attacker, Amnesty observes, and consequently, the Israeli army has increasingly conned more than 3 million Palestinians to some form of house, village, or town arrest. Moreover, the imposition of these mass arrests, according to Amnesty, is fundamentally discriminatory. They are imposed on the Palestinian population alone, and not on Israeli settlers, and are often imposed on Palestinians for the benefit of Israeli settlers. Even on occasions when Israeli settlers have initiated confrontations, attacking Palestinians, or destroying their property, the Israeli army invariably imposed closures, curfews, or other restrictions on the Palestinians, including by declaring a closed military area and excluding them from it. Finally, Amnesty notes that the Set. 198 Part 2. 15 Ibid, pages 15, soldiers enjoy, 24-25, not only a right, important to differentiate. Schlers constitute the main obstacle to restoring a semblance of normalcy in the occupied territories. Most of the restrictions on movement placed on Palestinians are imposed to prevent the Palestinian population from coming into contact with the Israeli settlers. 16 Israel's resort to widespread and prolonged closures, curfews, and other restrictions on movement currently imposed cannot be justified on security grounds, Amnesty concludes. The sweeping restrictions on the movement of Palestinians are disproportionate and discriminatory. They are imposed on all Palestinians because they are Palestinians, and not on Israeli settlers who live illegally in the occupied territories. They have a severe negative impact on the lives of millions of Palestinians who have not committed any offense, emphasis in original. 17 Besides claiming improved quality of life in the West Bank and Gaza, Dershowitz points to the spinet of the Israeli occupation in the case. A widespread punishment regularly meted out by soldiers at checkpoints is holding Palestinians on the spot for hours, with no shelter from sun or the rain, and in some cases placing men in metal cages. On Monday, July 14, 2003, the Israeli women group Moxam Watch, Checkpoint Watch, were alerted at 10:00 a.m. that Nasser Abu Jawdeh from Al Arab refugee camp was being held inside a metal cage, base area of 12 square meters, at the Gush Etzion checkpoint, between Hebron and Bethlehem, since 6 a.m., and that some 30 others were also held at the same checkpoint since 5:30 a.m. After Moxam Watch contacted the Israeli civil administration, the detainee was eventually released from the cage at approximately 12:00 noon and the others were allowed to leave at 1:30 p.m., that is, after up to 7 hours in the sun and heat. The previous week 2 other Palestinians had also been held in the cage together at the same checkpoint, one for 4 hours and the other, aged 17, for 7 hours. For Israel, ironically, being occupied by Israelis as distinguished from Jordanians and Egyptians also promoted Palestinian nationalism, p. 161. It is equally true that anti-Semitism promoted Jewish nationalism. Does it mitigate the evil of Nazism that it won world Jewry over to Zionism and facilitated the creation of a Jewish state? It seems not to have occurred to Dershowitz that perhaps the reason Israel's occupation, as compared to those of Jordan and Egypt, uniquely stimulated Palestinian nationalism is that it has been uniquely oppressive. In December 2003, the UN General Assembly called upon the International Court of Justice, ICJ or World Court, to render an advisory opinion on the legal consequences arising from Israel's construction of a wall cutting deeply into the West Bank. Alan Dershowitz, who was advising Israeli officials on confronting the court, denounced the World Court, claiming that it would conduct an Alice in Wonderland legal proceeding and that it would be insulting to kangaroos to call it a kangaroo court. Maintaining that a verdict against Israel was a foregone conclusion, he went on to liken the ICJ to racist courts in the American South during the Jim Crow era, which could do justice in a lawsuit brought by a white against a white, but did horrible racist injustices in cases involving whites against blacks. The ICJ could accordingly do a wonderful job in a border dispute between Sweden and Norway, but when it comes to anything having to do with the Middle East it has zero credibility. And nobody should take seriously any conclusion it reaches with regards to Israel. Dershowitz provides no evidence or argument for any of these claims about the World Court. Even if they do complement his pronouncement quoted in Part I of this book that Israel is not bound by international law. In addition, Dershowitz justifies Israel's construction of the wall as its last alternative to combating terrorism. 18. What is the merit of this argument? In April 2002, the Israeli cabinet publicly announced that fences and other physical obstacles would be constructed to improve and reinforce the readiness and operational capability in coping with terrorism, and in June 2002 it approved the RST phase of the project. Consisting of concrete walls, ditches, trenches, roads, razor wire, and electronic fences, stretching for fully 680 kilometers and averaging 60 meters in width. The portion of the wall approved by the Israeli government as of October 2003 will have severe humanitarian consequences for more than 680,000 Palestinians living in the West Bank, 30% of its population. Only 11% of the wall runs along Israel's internationally recognized boundary, the Green Line, the remainder of it cutting off some 15% of the West Bank, including some of its richest land and water resources, as well as 274,000 Palestinians, who will live either in closed areas between the wall and the Green Line or in enclaves totally surrounded by the wall. More than 10,000 of these Palestinians must already apply for green-colored permits, valid for up to 6 months, to continue residing in their homes. These permits, a UN report concludes, have turned the right of Palestinians to live in their own homes into a privilege. Another 400,000 Palestinians living to the east of the wall will need to cross it in order to reach their farms, jobs, and social services, while yet another 200,000 to 300,000 Palestinians living in East Jerusalem will be cut off from the West Bank. The plan for the wall calls for several gates and crossings to enable passage of people and goods, although the modalities of such passage have yet to be formalized. Whatever the crossing arrangements will be, it is clear that hundreds of thousands of Palestinians will be dependent on Israel's security system when they want to cross the barrier from either side, observes B'Tselem, while past experience raises the fear that the crossing points along the barrier will be closed for prolonged periods and the passage of Palestinians may be completely prohibited. Even if the barrier does not create total isolation, B'Tselem concludes, it will clearly reduce the ability of many residents to work and earn sufficient income to ensure a minimum standard of living, and it is liable to force additional thousands of Palestinian families into poverty. Some 600 shops and enterprises have reportedly closed in the town of Kalkalia alone due to the wall's construction. Huge swaths of Palestinian land on which the wall is to be erected have already been subject to a disguised expropriation of property, and much more Palestinian land west of the wall is likely to be confiscated in the future. Even crediting Israel's argument that it was blight unto the nation's 201. For the purpose of beating terrorism, such expropriation, according to human rights organizations, is illegal under international law. While landowners are entitled to demand compensation, the vast majority have not done so, on the urging of the Palestinian Authority, a University of Oxford study further notes, so as not to legitimize the Israeli seizure. In any case, the amount of compensation offered has been well below the real value of the land in Kalkalia, for example, only 10% of the actual value. After taking control, B'Tselem reports, the contractors level the land by uprooting the crops, including eld crops, greenhouses, and, primarily, olive trees. An estimated 100,000 trees have been uprooted in the course of the wall's construction. With official sanction, uprooted Palestinian olive trees have been subsequently sold by the Israeli contractors for profit to themselves in Israel. 19 Like Dershowitz, the Israeli government has maintained that construction of the wall was undertaken only after all other options for curbing the wave of terror had been exhausted. Human rights organizations dispute this, however. The Israeli government has itself acknowledged that most Palestinian suicide bombers entering Israel passed through inadequately supervised checkpoints. Security at these checkpoints could have been beefed up, while Israeli troops could have been deployed along the open areas between the checkpoints. In addition, if its concern was curbing terrorist attacks on Israel proper, the government could simply have erected the wall along the Green Line, which would have been legally unobjectionable. As Amnesty notes, it is not unlawful for Israel to establish fences or other structures on its own territory to control access to its territory. Finally, the Oxford study observes that if the barrier is meant to prevent suicide bombings, it is unclear why Israel is apparently unconcerned about the hundreds of thousands of Palestinians who will end up on the Israel side of the barrier. unless it is ultimately planning to remove them, more on which presently. 20. The real motive behind construction of the wall appears to be securing for Israel its settlements in the West Bank. Winding around scores of Jewish settlements that house more than 320,000 settlers, 80% of the total, the wall will not just serve to protect them but, crucially, will enable their annexation, along with adjoining land and water resources, to Israel. Uncontroversially, the settlements are illegal indeed, they constitute war crimes under international law. Even Dershowitz exerts no effort in the case for Israel to justify them. Erecting a wall that inflicts massive injury on Palestinians in order to protect illegal settlements would mean compounding one injustice with another. The Israeli government cannot use security concerns for Israelis living in illegal settlements, Human Rights Watch observes, to justify further encroachments into occupied territory. In fact, however, these Jewish settlements could be protected without erecting a wall, for example, by surrounding them with electric fences, as will be done with those falling outside the wall. The underlying reason for the wall, B'Tselem suggests, is not to provide maximum protection of the settlers but rather to establish facts on the ground that would perpetuate the existence of settlements and facilitate their future annexation into Israel. Likewise, Human Rights Watch concludes that the existing and planned route of the barrier appears to be designed to incorporate and make contiguous with Israel illegal civilian settlements. The de facto new boundary created by the wall will, if a planned extension along the Jordan Valley wins approval, ultimately incorporate about half the West Bank. The indigenous Palestinian population, including those currently residing between the wall and Israel but who will be forced by intolerable living conditions to relocate on the Palestinian side of it, voluntary transfer, will be trapped in a fragmented territory resembling the South African Bantustans and comprising some 10% of historic Palestine. Human Rights Watch has urged the U.S. government to deduct the cost of the West Bank separation barrier from U.S. loan guarantees for Israel. 21. Contrary to Dershowitz's claim, the wall is not Israel's last alternative to combating terrorism, nor, for that matter, is it designed to GHT terrorism. The facts are clear, as is the consensus among human rights groups about them. The real purpose of the wall is to decide, preemptively, unilaterally, and definitively, the future of the Jewish settlements. Dershowitz correctly anticipated that, were the International Court of Justice to accept the case, a verdict against Israel would be a foregone conclusion, not because the ICJ is a kangaroo court, however, but because the injustice against Palestinians is so transparent, if not to Dershowitz, at any rate even to a kangaroo. In July 2004 the World Court handed down its advisory opinion Legal Consequences of the Construction of a Wall in the Occupied Palestinian Territory, General List No. 131. By a vote of 14-1, United States, it concluded that the construction of the wall being built by Israel, the occupying power, in the occupied Palestinian territory, including in and around East Jerusalem, and its associated regime, are contrary to international law, that Israel is under an obligation to terminate its breaches of international law, it is under an obligation to cease forthwith the works of construction of the wall being built in the occupied Palestinian territory, including in and around East Jerusalem, to dismantle forthwith the structure therein situated, that Israel is under an obligation to make reparation for all damage caused by the construction of the wall in the occupied Palestinian territory, including in and around East Jerusalem, that the United Nations, and especially the General Assembly and the Security Council, should consider what further action is required to bring to an end the illegal situation resulting from the construction of the wall and the associated regime. By a vote of 13-2, United States, Netherlands, it also found that ALL states are under an obligation not to recognize the illegal situation resulting from the construction of the wall and not to render aid or assistance in maintaining the situation created by such construction. All states parties to the Fourth Geneva Convention relative to the protection of civilian persons in time of war of August 12, 1949 have in addition the obligation, while respecting the United Nations Charter and international law, to ensure compliance by Israel with international humanitarian law as embodied in that convention. Apart from these endings of the court, the decision was noteworthy in other respects as well. On a semantic point, it upheld usage of the term wall to designate the structure Israel is building, para 67. It repeatedly cited the preambular paragraph of UN Security Council Resolution 242, which emphasizes the inadmissibility of the acquisition of territory by war, as well as a 1970 UN General Assembly resolution emphasizing that no territorial acquisition resulting from the threat or use of force shall be recognized as legal, denoting this principle a corollary of the UN Charter and as such customary international law and a customary rule, para 74, 87, 117. It upheld the applicability of the Fourth Geneva Convention to the occupied territories, para 101. It found that the Israeli settlements in the occupied Palestinian territory, including East Jerusalem, have been established in breach of international law, para 120. On all these counts, the World Court's endings represent a sweeping repudiation of the official Israeli position. Even the dissenting statement of the U.S. representative on the court crucially conceded that the Fourth Geneva Convention applied to the occupied territories and that the existence of Israeli settlements in the West Bank violates the convention, declaration of Judge Bjurgenthal. On the latter point it bears notice that, against the consensus of legal opinion and in a category virtually all his own, Dershowitz upholds the legal rights of the Jewish settlers to live anywhere in the West Bank and in Gaza. 22. 9. High Court takes the low road. Alan Dershowitz has always lavished unstinting praise on Israel's Supreme, or High, Court. 1. During the First Intifada, he typically declared, Israel's Supreme Court has responded magnificently to the occasional overreactions of the Israeli army and security officials. That court, which is among the best in the world, has repeatedly ruled in favor of Arab claimants who have been treated unfairly. 2. In Why Terrorism Works, published after the outbreak of the Second Intifada, Dershowitz similarly asserted, despite significant restrictions on the rights of Palestinians, they know that the Supreme Court of Israel stands as an independent bastion of liberty, even when the military or the government seeks restrictions. 3. The exemplary performance of the Supreme Court goes as a central theme of the case for Israel. Its Supreme Court is among the best in the world, and it has repeatedly overruled the army and the government and made them operate under the rule of law. The Israeli Supreme Court is by all accounts one of the best in the world. Although obviously sensitive to the need for security, the Israeli Supreme Court has repeatedly enjoined the Israeli government and its military from undertaking actions in violation of the highest standards of the rule of law, p. 183, and so forth. Dershowitz dedicates the case for Israel to Aharon Barak, the current president of Israel's Supreme Court, whose judicial decisions make a better case for Israel and for the rule of law than any book could possibly do. Yet those knowledgeable on this subject reach diametrically opposed conclusions. What renders Israel's abuses unique throughout the world, the executive director of B'Tselem, Israeli Information Center for Human Rights in the Occupied Territories, observes, is the relentless efforts to justify what cannot be justified. For Israel's Supreme Court has served as the main judicial instrument for this justifying of the unjustifiable. The most exhaustive study to date of Israel's Supreme Court decisions regarding the Palestinians is David Kritzmer's The Occupation of Justice, the Supreme Court of Israel and the Occupied Territories. The central endings of Kritzmer, a distinguished professor of law at the Hebrew University of Jerusalem, merit extensive quotation. The court has interfered infrequently in decisions of the military. In almost all of its judgments relating to the occupied territories, especially those dealing with questions of principle, the court has decided in favor of the authorities, often on the basis of dubious legal arguments. It is indeed true that in a few cases the court has decided against the authorities. However, these landmark cases serve only to enhance the legitimizing function of the court by reinforcing the image of the court as an impartial body which boldly challenges the government in pursuit of justice. While the court has frequently mentioned the duty of the commander to balance security factors with other considerations, it has almost invariably refused to enter the balancing issue itself, and has bowed to the discretion of the military commander. The duty to balance has more often been part of the court's rhetoric than of its actual decision-making. The court has not seen itself as a body that should question the legality under international law of policies or actions of the authorities, or should interpret the law in a rights-minded fashion. On the contrary, it has accepted and legitimized policies and actions the legality of which is highly dubious, and has interpreted the law in favor of the authorities. In its decisions relating to the occupied territories, the court has rationalized virtually all controversial actions of the Israeli authorities, especially those most problematic under principles of international humanitarian law. The jurisprudence of these decisions is blatantly government-minded. 5. In his analysis of specific decisions, Kritzmer typically describes the reasoning of the court as highly questionable, highly problematic, sophistry, and so on. 6. Table 9. 1 reports the endings of human rights organizations and scholars on the legality of key Supreme Court decisions regarding the occupied territories. Table 9. 2. Samples other court decisions regarding the occupied territories. The sections below titled Vote of Confidence, Required Reading, Bargaining Chips, and Equality examine Dershowitz's attempts to prove that the Israel Supreme Court defends Palestinian rights, while the last, Frightening Order, uses Dershowitz's standard to judge Israel's legal system in the occupied territories. Vote of Confidence. To demonstrate the Israel Supreme Court's defense of Palestinian rights, Alan Dershowitz quotes a Palestinian human rights activist on page 184 of the Case for Israel. Even Rajai Sawarani, the director of the Palestinian Center for Human Rights in Gaza and a strident critic of Israel, says that he remains constantly amazed by the high standards of the legal system. Cited from the New York Times, the passage reads in full, "Despite his many frustrations with the Israeli courts, Mr. Sawarani says he remains constantly amazed by the high standards of the legal system. On many issues," he said, "when the courts are dealing with purely Israeli questions, like gay rights, I admire their rulings. But when it comes to the Palestinians, these same people seem to be totally schizophrenic," emphases added. 7. Residency and family. Unication. Political liquidations. Access to medical care. The court accepted the legitimacy of the policy according to which marriage of a resident to a non-resident was not a good enough reason for allowing the non-resident to live permanently in the area. The Israeli High Court has dismissed 2 petitions regarding state assassinations on the grounds that the court does not usually render rulings on security matters. In so doing, the Israeli High Court adopted the position of the state BPHR Physicians for Human Rights, Israel and the Palestine Red Crescent Society jointly petitioned the High Court, arguing that Israel is violating its undertaking to enable the passage of sick persons through the roadblocks that dissect the occupied territories. The High Court rejected the petition. The Court refused to accept an affidavit from the Palestine Red Crescent Society detailing 121 cases reacting the delay or prevention of passage of patients or medical personnel at the checkpoints. The court also refused to issue an order requiring the state to observe the procedures to which it had committed itself. The High Court also accepted the state's claim that there were no villages or regions in the West Bank and Gaza Strip to which access was completely blocked by physical roadblocks. This argument that no areas were inaccessible has been repeatedly disproved. See required reading. To illustrate the Israel Supreme Court's protection of the rights of Palestinians, Alan Dershowitz writes on pages 184-86 of the Case for Israel, on September 3, 2002, the court decided a case in which the Israeli military ordered the expulsion of the sister and brother of a terrorist who had organized several suicide bombings. They were expelled from the West Bank for a period of 2 years and moved to the Gaza Strip on the basis of a ending that the sister had sewn explosive belts and the brother served as a lookout when his brother and members of his group moved 2 explosive charges from one place to another. The court ruled that the expulsion order, which constituted a temporary assignment of residence within the occupied territories rather than a transfer out of the territories, was valid only if the person himself who is being expelled presents a real danger. Dershowitz goes on to recommend this decision as required reading for those who claim that Israel does not comply with the rule of law. The decision, a jury v. IDF commander, was written by President of the Court Aharon Barak. The original conviction of the defendants, Intisar Muhammad Ahmed Ajuri and Ahmed Ali Ajuri, was based on privileged material and testimonies of members of the General Security Service. Barak nonetheless affirms it. We asked counsel for the state why the petitioner is not indicted in a criminal trial. The answer was that there is no admissible evidence against her that can be presented in a criminal trial, for the evidence against her is privileged and cannot be presented in a criminal trial. We regard this as a satisfactory answer. 8. Thus, Dershowitz judges exemplary the court's decision to uphold forcible transfer on the basis of secret evidence. According to Amnesty International, however, it violated fundamental provisions of international law. The ruling effectively allows for a grave violation of one of the most basic principles of international human rights law, notably the right of any accused to a fair trial and to challenge any evidence used against them. The ruling also allows for a grave breach of international humanitarian law. According to the Fourth Geneva Convention, Palestinians living in the territories which have been under Israeli military occupation since 1967 are protected persons. The unlawful forcible transfer of protected persons constitutes a war crime. Under the Rome Statute, such violations may also constitute crimes against humanity. In its decision today, the High Court of Justice ruled that forcible transfer to the Gaza Strip can only be used for people who have been personally involved in serious crimes and cannot be used as a deterrent. However, Amnesty International believes that such unlawful forcible transfer of relatives of people allegedly responsible for attacks against Israelis is being used by the Israeli government and army as a form of collective punishment. Such a measure is forbidden by Article 33 of the Fourth Geneva Convention. 9. Amnesty subsequently reported that the Ajuris remain in the Gaza Strip, where they have no family, no home, and no means of subsistence other than charity. 10. Bargaining chips. To demonstrate that the Israel Supreme Court is by all accounts one of the best in the world, Alan Dershowitz cites this decision on page 185 of the Case for Israel. The Israeli Supreme Court has prohibited Israel from holding prisoners as bargaining chips for the exchange of prisoners illegally being held by its enemies. It is correct that the Supreme Court prohibited hostage-taking in an April 2000 decision. Dershowitz omits mention, however, of the precedent and consequence of this decision. It came only after the Supreme Court legalized hostage-taking. 21 Lebanese nationals had been imprisoned in Israel. Human Rights Watch, HRW, reported in a comprehensive 1997 study, for up to 10 years, some, in secret locations, denied even the guarantees of due process and humane treatment required by the laws of war. Several had reportedly been tortured during interrogation in South Lebanon with electric shocks administered by Lebanese mercenaries in the presence of Israelis who gave orders. They were being held as hostages, according to HRW, in order to secure the release of Israeli POWs and MIAs from the Lebanon War. 11 In a November 1997 ruling unprecedented in the world, Amnesty International. 12 The Israel Supreme Court authorized the use of these Lebanese detainees as bargaining chips. President of the court Aharon Barak held that a detention is legal if it is designed to promote state security, even if the danger to state security does not emanate from the detainees themselves. And that detention of the appellants for the purpose of release of the captured and missing soldiers is a vital interest of the state. 13 The court's ruling is contemptible and explicitly legitimizes hostage-taking, Amnesty declared. These are real people, not objects to be used as political pawns. 14 Deploring the decision, B'Tselem observed that Israel has granted legitimacy to one of the trademarks of terrorist groups around the world. 15 In his April 2000 reversal, Barak himself acknowledged that there is probably no state in the Western world that permits an administrative detention of someone who does not himself pose any danger to state security, and that holding persons as bargaining cards actually means holding them as hostages. It bears notice that among the grounds Barak adduced for his reversal was the strictly pragmatic one that there is no probability or even a reasonable possibility that the continued detention of the petitioners would lead to the release of the captured and missing soldiers. 16 Even after the 2000 decision, 2 of the Lebanese detainees continued to be held incommunicado in a secret place of detention as hostages, Amnesty International. 17 In 2000 the Israeli cabinet approved draft legislation, imprisonment of combatants not entitled to prisoner of war status law, to legalize hostage-taking, HRW. 18 In 2001 an Israeli court renewed both men's detention orders, after the state contended that their release endangered national security. 19 In 2002 the Israeli Knesset approved the imprisonment of combatants law. 20 In January 2004, the 2 Lebanese hostages were freed in a prisoner swap with Hezbollah. Equality. To demonstrate that Israel is not a racist state, Alan Dershowitz writes on page 157 of the Case for Israel. A decision by the Israel Supreme Court in 2002 ruled that the government may not allocate land based on religion or ethnicity and may not prevent Arab citizens from living wherever they choose. In March 2000 the Supreme Court ruled that in principle the state couldn't directly or indirectly allocate land to its citizens on the basis of religion or nationality, although it also allowed that under unspecified special circumstances, discrimination might be permissible. The decision itself applied only to state-owned land and not land owned by the Jewish National Fund, whose holdings are considerable. Apart from these last caveats, let us also put to one side that when Dershowitz 216 Part 2 had been defending Israel's sterling democracy prior to 2000, it had been, by his own admission now, discriminating against its Arab citizens. In the case at hand, the court held that the State of Israel must consider the petitioner's request an Arab couple named Ka*Adon to acquire land for themselves in the settlement of Katsir for the purpose of building their home and must determine with deliberate speed whether to allow the petitioners to make a home within the communal settlement. 21 In April 2001 the High Court rejected another petition led by ACRI Association for Civil Rights in Israel against ILA Israel Lands Administration, the Jewish Agency, and the settlement of Katsir for contempt of court. ACRI claimed these bodies had not carried out the High Court's precedent-setting Ka*Adon ruling. The respondents argued that they retained the right to interview the Ka*Adon family before reaching a decision. They were instructed to do so by the court within 60 days. In November 2001, the Katsir Admissions Board rejected the Arab couple's application, Human Rights Watch. 22 In May 2004, the Israel Lands Administration informed the Ka*Adon family that they could purchase a plot of land and build a house in Katsir, but Haaretz reported in June 2005 that 10 years after they petitioned the court and 20 years after the court decided in their favor, the Ka*Adon family is still not living there. 23 Meanwhile, on another front, in July 2002 the government decided to support a bill that would enable state land to be apportioned for Jewish use only, annulling, if passed, the court's already circumscribed decision. 24. Frightening Order. On pages 214 to 17 of Why Terrorism Works, Alan Dershowitz warns of the dangers of a frightening order issued by the Bush administration, a long-term resident of the United States who President Bush believes may have aided a terrorist can now be tried in secret by a military commission. Non-citizens suspected of membership in Al-Qaeda, or of harboring an aim to cause injury or adverse effects on the United States, can be rounded up and detained at an appropriate location for an indefinite time without access to the courts. Nor will the suspect have an adequate opportunity to defend himself, since the ordinary rules of evidence will not be followed. The military commission will be allowed to base its decision on any evidence that would have probative value to a reasonable person. Translated from the legalese, This means that hearsay, coerced confessions, and the fruits of illegal searches can be considered, and that cross-examinations will not always be allowed. It also means that the prosecution need not even disclose the sources of its hearsay if such disclosure would reveal a state secret, a broad term that is nowhere specifically deemed. On pages 242 to 43 of Why Terrorism Works, he likewise deplores laws instituted by the Nazis right after seizing power that did not include any provision guaranteeing an arrested person a quick hearing, access to legal counsel, or redress for false arrest. Those arrested often found their detention extended indefinitely without legal proceedings of any kind. A 1991 Amnesty International study entitled The Military Justice System in the Occupied Territories, Detention, Interrogation, and Trial Procedures reported these endings regarding the tens of thousands of Palestinian civilians tried before military courts in the occupied territories since 1967. Detainees are held in prolonged incommunicado detention. They are normally not brought before a judge for 18 days. They may be prevented any meaningful contact with their lawyers and relatives well after that, in any case until interrogation is over, which is often 20 or 30 days after arrest. Confessions obtained under interrogation during this period of incommunicado detention are often the primary evidence against defendants appearing before the military courts. Many defendants claim that these confessions are false and have been obtained by the use during arrest and interrogation of torture or other forms of cruel, inhuman, or degrading treatment or punishment. The lack of safeguards in the system to protect against torture and ill treatment, as well as the evidence accumulated over the years, lends credibility to these claims. Regarding the offenses tried before military courts, Amnesty observed that in sweeping terms one military order criminalizes and makes punishable by up to 10 years imprisonment almost every form of political expression in the occupied territories, including nonviolent forms of political activity, such as raising the Palestinian flag, wearing its colors or making the V sign. 25. In lieu of military trials, Israel has also resorted to administrative detention, that is, imprisonment without charge or trial. Under international law, it can be imposed only when an individual poses an imminent danger that can't be otherwise averted. A 1992 B'Tselem study entitled Detained Without Trial, Administrative Detention in the Occupied Territories Since the Beginning of the Intifada reported these endings regarding over 14,000 administrative detention orders that have been issued to Palestinians since the beginning of the Intifada. A great number of detainees are placed in administrative detention after their interrogators fail to elicit a confession, or as a form of collective punishment, or simply because it is simpler to detain them without charge than to bring them to trial. Appeals by Palestinian detainees take place at least 1 month after their arrest, while most are heard even later. The overwhelming majority of the evidence on which the detention is based is considered confidential. The appellant and his lawyer are not shown this evidence, and receive only summary information that is not substantial enough to be contested. Many detainees do not know on what grounds they were detained. Among the administrative detainees are many Palestinian journalists, trade unionists, physicians, merchants, laborers, and students. Palestinian leaders who openly support the peace talks with Israel and dialogue to promote Palestinian-Israeli understanding also number among the administrative detainees. In recent years, a Jewish-Palestinian dialogue group has been meeting in Beit Sahur. Almost all of the Palestinian members of this group have been held in administrative detention. 26. As of 1991, each administrative detention order was for up to 6 months, renewable for successive 6-month periods. A subsequent B'Tselem study, Prisoners of Peace, Administrative Detention During the Oslo Process, 1997, found that Israel continues to employ administrative detention on a large scale, that the period for each detention order was extended to up to 1 year, renewable for 6-month periods, that length of detentions has increased dramatically, 11 detainees having been held for over 3 consecutive years, that administrative detention was imposed on those engaging in nonviolent political activity and the expression of political opinions, as well as on minors as young as 15 years of age, and that either before or during their administrative detention, individuals may be subjected to interrogation methods which constitute torture or other ill treatment. 27 In 1998, Human Rights Watch called on Israel to immediately end the practice of arbitrary or prolonged administrative detention, and revise its laws to ensure that all detainees are guaranteed at minimum the right to prompt and effective judicial review of the lawfulness and conditions of their detention, the right to receive an explanation of one's rights upon arrest in one's own language or soon thereafter, and to be informed of the specific, detailed, and personalized reasons for the deprivation of liberty, the right of immediate access to family, legal counsel, and a medical officer. 28 B'Tselem reports that as of March 2003, Israel held more than 1,000 Palestinians in administrative detention. 29 It seems that the frightening order Dershowitz warns of in the United States was implemented long ago in the occupied territories. Conclusion. The next task facing the legal profession is to make it easier for the ordinary citizen to tell the difference between the honest lawyer and the shyster. Alan M. Dershowitz, Letters to a Young Lawyer. A wide and diverse array of human rights organizations, Palestinian as well as Israeli, United Nations, affiliated as well as independent groups with a global mandate, have closely monitored Israeli conduct in the occupied territories. Both their conclusions regarding application of international law and their factual determinations on major as well as minor details are remarkably consistent. In many respects, Israel's record, as distilled from thousands of pages of human rights reports, is quite singular. What renders Israel's abuses unique throughout the world, B'Tselem observes, is the relentless efforts to justify what cannot be justified. The Israel Supreme Court has rationalized virtually all controversial actions of the Israeli authorities, Hebrew University professor David Kritzmer. For example, in a 1997 ruling unprecedented in the world, Amnesty International, the Supreme Court legalized hostage-taking. As of November 2003, well over 2,000 Palestinians had been killed in the current intifada, overwhelmingly civilians. When so many civilians have been killed and wounded, the lack of intent makes no difference, B'Tselem concludes. Israel remains responsible. Indeed, New York Times reporter Chris Hedges has observed regarding his stint in Gaza, I had seen children shot in other conflicts I have covered. But I had never watched soldiers entice children like mice into a trap and murder them for sport. Israel was the only country in the world, according to B'Tselem, where torture was legally sanctioned. Since the beginning of the occupation in 1967, Israel has routinely tortured Palestinian political suspects, Amnesty International. Due to this systematic pattern, Human Rights Watch estimated in 1994, the number of Palestinians tortured or severely ill-treated, often without even a pretense that these detainees were guilty of any wrongdoing, is in the tens of thousands. Torture declined after a 1999 Israel Supreme Court decision, but, according to the Public Committee Against Torture in Israel, has since been reinstituted in a methodical and routine fashion. According to Human Rights Watch, apart from Iraq under Saddam Hussein, Israel has been the only country in the world resorting to house demolitions as a form of punishment. In addition to such punitive demolitions, illegal under international law, of more than 2,000 Palestinian homes, Israel has also been condemned for demolishing thousands more Palestinian homes on spurious administrative and security grounds. Israel is the only democratic country that regards political liquidations as a legitimate course of action, B'Tselem, placing it among an infamous group of states that grossly violates basic moral and humane norms that the international community considers binding. Public Committee Against Torture in Israel and the Palestinian Society for the Protection of Human Rights. Israel presents no evidence supporting its charges against those targeted for assassination. The targets typically don't pose any imminent danger and, alternatively, could have been apprehended, while numerous bystanders have been indiscriminately killed and injured. Israel's economic policies in the occupied territories have proven more exploitative than those of other settler regimes, Harvard research scholar Sarah Roy, resulting in the massive illegal expropriation of Palestinian land and vital water resources. Mainly on account of Israel's closure policy, the West Bank and Gaza currently verge on a humanitarian catastrophe, UN Commission on Human Rights. Finally, Israel's regime of separation in the occupied territories is the only one of its kind in the world, according to B'Tselem, and is reminiscent of distasteful regimes from the past, such as the apartheid regime in South Africa. Yet, against this copiously documented record of egregious human rights violations, Alan Dershowitz contends, and purports to have proven, that Israel's human rights record in the occupied territories is generally superb. The chasm separating these respective accounts of 222 Part 2. Israel's record cannot be bridged. Either mainstream human rights organizations and independent experts have engaged in a vast anti-Semitic conspiracy to defame Israel, or Dershowitz has egregiously misrepresented the factual record. No third possibility exists. Beyond his presentation of Israel's human rights record, Dershowitz has taken significant personal initiatives that merit notice. His early legal defense of Israeli house demolitions was deemed by Israel's leading authority on international law as verging on the bizarre. He is on record as supporting collective punishment, including the automatic destruction of a Palestinian village after each Palestinian attack. Repeatedly disregarding and distorting evidence, Dershowitz publicly claimed in 1970 that a Palestinian under administrative detention was a terrorist leader, in 1979 that a Palestinian detainee had not been held incommunicado and that his lawyer did not maintain he had been tortured, and in 1989, in sworn testimony, that the most extreme tactic of Israeli interrogators was an occasional physical touching. He currently advocates the application of excruciating torture on suspected terrorists such as a needle being shoved under the entrails. When Israeli Air Force pilots issued a public statement deploring the immorality of political liquidations, Dershowitz publicly aligned himself with the Israeli government in denouncing these courageous dissenters. When young members of the international solidarity movement nonviolently protesting Israeli human rights violations were injured and killed by Israeli soldiers, he denounced them as supporters of Palestinian terrorism. Dershowitz has called for a reversal of the last century's progress in international humanitarian and human rights law, dismissing ethnic cleansing, for example, as a FTH rate issue akin to massive urban renewal. And, at a conference in Israel attended by Prime Minister Sharon, he declared that Israel was not at all bound by international law. Dershowitz is also a senior professor of law at Harvard University, where he has taught legal ethics, and is widely acclaimed in the United States as a leading civil libertarian. There is illuminating precedent for Dershowitz's defense of civil liberties at home and apologetics for their egregious violation abroad. Communist Party members often proved the most steadfast defenders of civil liberties in the United States. Elizabeth Gurley Flynn was a founding member of the American Civil Liberties Union and, simultaneously, a leading member of the American Communist Party during its years of blind support for Stalin's Russia. Likewise, communists and sympathizers led the ranks of the National Emergency Civil Liberties Committee, the National. Conclusion 223. Lawyers Guild, and other organizations defending basic human rights. To reconcile their avowed commitment to civil liberties with slavish support for the Soviet Union, communists used to maintain both that the Soviet system was the most democratic in the world, witness the 1936 Soviet Constitution, and, with little regard for consistency, that in the face of the threats to its survival, both external and internal threats, to borrow Dershowitz's phrase, the Soviet Union couldn't allow itself the luxury of bourgeois rights, which primarily served its enemies. Substitute luxury of human rights for luxury of bourgeois rights, and you get Dershowitz on Israel. When the United States joined ranks with the Soviet Union in the war against fascism, the Communist Party abandoned its prior commitment to civil liberties at home, supporting government suppression of political dissenters. When the United States joined ranks with Israel in the war against terrorism, Dershowitz began advocating draconian domestic legislation like the torture warrant. Yet no analogy is perfect. However corrupted, the ideals of communists were real, as were the sacrifices they made for these ideals. The likes of Dershowitz are opportunists, and their purported defense of Israel in the face of overwhelming opposition is all theater. A recurrent theme of Alan Dershowitz's writing is that, just like everyone else, those in high positions of authority should be held accountable for their malfeasance. I feel a special responsibility, he professes in The Best Defense, to expose the cheat elite form of corruption. He cites as one egregious example judges who have made false claims about what they have read, distorted records, and engaged in other deceptions. One in The Vanishing American Jew, he excoriates the lectures of Afrocentric demagogues like City University of New York professor Leonard Jeffries. It is not scholarship. It is not even propaganda. It is educational malpractice. The primary victims are not those who are the targets of Jeffries's attacks. The real victims are the students whom Jeffries defrauds of their time and tuition on a daily basis in the classroom. 2. In the case for Israel, Dershowitz decries as a particularly nasty form of educational malpractice those who set out quite deliberately to misinform, miseducate, and misdirect their own students, p. 207, and calls for the sacking of professors like an obscure French Holocaust revisionist who publishes spurious scholarship. There was no extensive historical research. Instead, there was the fraudulent manufacturing of false anti-history. It was the kind of deception for which professors are rightly fired not because their views are controversial but because they are violating the most basic canons of historical scholarship, p. 213. 3. Shouldn't those at Harvard Law School also be held to this standard? In The Holocaust Industry, this writer documented that American Jewish elites didn't become enamored of Israel until after the June 1967 war, when it became politically and personally expedient to be a Zionist. 4. Likewise, they didn't discover the Nazi Holocaust until after the June War, when it proved useful for dictating criticism of Israel. Alan Dershowitz perfectly ts this prole. He reports that it was only in 1967 that IRST began to make the case for Israel on university campuses, in the media, and in my writings, p. 7, that is, when it required roughly as much pluck as for his counterpart at Moscow University to make the case for Cuba. He also informs readers that the Nazi Holocaust didn't occur at all in his life growing up. I do not remember any discussion, not a single one, either in class, in the schoolyard, or even at home, about the Holocaust. The Holocaust was not part of my personal memory. It was never mentioned in yeshiva, in Jewish camp, in discussions among my friends, or even at the synagogue. 5. And again, my friends from Brooklyn and I, who never discussed the Holocaust when we were growing up, talk about it all the time now. 6. No doubt they do, since, in contrast to the 1950s, it's now politically convenient to invoke the Nazi Holocaust. 7. Dershowitz's convenient love affair with Israel and anguish over the Holocaust points to the ugliest truth about his wretched book. Throughout the past year this writer has stated in public lectures that the case for Israel is replete with egregious falsehoods. Yet the biggest fraud is the title itself. Dershowitz hasn't written a case for Israel. How could anyone genuinely concerned about the Israeli People Council policies certain to sow seeds of hatred abroad and moral corruption within? What he has in fact written is the case for the destruction of Israel. Letting others, Palestinians as well as Jews, pay the price while he plays the tough Jew, isn't this what Dershowitz's chutzpah really comes down to? 226 Part 2. 227. Israel prides itself on governing by the rule of law. Yet human rights organizations have copiously documented that it has committed massive violations of international law in the occupied Palestinian territory. 1. In the division of burdens for maintaining the occupation, Israel's High Court of Justice, HCJ, has performed the crucial ideological function of reconciling Israel's enlightened avowals with its egregious practices. Whereas human rights organizations have found that Israel has grossly violated international covenants on torture, collective punishment, and so forth, the HCJ has repeatedly found that Israeli practices fully conform to international law. 2. The HCJ opinions on the legality of the wall Israel has been constructing in the West Bank mark a continuation and culmination of its postscript. Reconciling irreconcilables. How Israel's High Court of Justice proved the wall was legal. Rationalizing function. 3. In an advisory opinion, the International Court of Justice, ICJ, voted overwhelmingly that the wall's construction in the West Bank violated international law, for whereas the HCJ has repeatedly upheld the legality of such a wall. Nonetheless, in keeping with its professed respect for the rule of law including the authority of the World Court, the HCJ has maintained that its judgments accord with the legal norms set forth in the advisory opinion. The disagreement between them, according to the HCJ, bears not on the normative legal framework but rather on the data on which their respective decisions were reached. If the ICJ reached an altogether different conclusion from the HCJ, it was allegedly because the ICJ was ill-informed regarding the facts on the ground. The upshot of the HCJ opinions is that Israel's construction of the wall in the occupied Palestinian territory is both in accord with international law and consistent with the advisory opinion. I will argue that the HCJ's reconciliation of its rulings with those of the ICJ is disingenuous. Contrary to the HCJ's claim, the factual basis upon which it and the ICJ rendered their respective opinions is fundamentally the same. The HCJ was only able to sustain the legality of the wall by blindly deferring to the state's military authority, peremptorily dismissing challenges to it, and sanctioning flagrant violations of international law, as interpreted by the ICJ as well as all other international bodies. Despite its pious lip service to the rule of law, the HCJ once again breached it in the service of raison d'etat. In addition, I will argue that the HCJ decisions on the wall are themselves riddled with internal contradictions. The court both defers absolutely to the military authority of the state and disputes the state's military rationale for segments of the wall, in the process undercutting the basis of the court's own ending of the military necessity of the wall. Although the HCJ's opinions on the wall tee into a long-established pattern of lending a cloak of legality to illegal practices, it would be difficult to exaggerate the pernicious consequences of these particular opinions. Apart from the humanitarian crisis it has wrought, the wall, once completed, will nearly bisect the West Bank, cut off the West Bank from its hub in Arab Jerusalem, and deprive the West Bank of some of its most productive land and water resources. In other words, it will preempt any possibility of a two-state settlement, condemning Palestine and Israel to endless bloodshed. If all branches of Israeli government and society bear responsibility for this impending catastrophe, the share of the HCJ and especially its liberal Chief Justice, Aharon Barak, is relatively larger. Due to its moral authority, the HCJ was in a unique position to sensitize the Israeli public. Beyond helping fend off external criticism of Israel's annexationist policies, the HCJ chose to mute the collective Israeli conscience. The order of inquiry in this chapter will be, RST, to summarize the main endings of the ICJ opinion. I will show that the ICJ opinion was based on the general ending that the wall cannot be justified by military necessity and on the specific ending that the infringements of Palestinian rights attendant on the wall's construction violate international law. Second, I will scrutinize the HCJ's justification for sanctioning the wall to protect Israel proper. I will argue that the HCJ provided no credible evidence that a wall encroaching on West Bank territory was necessary to protect Israel proper from terrorist attacks, and that the HCJ ignored options affording Israel protection without infliction of additional suffering on Palestinians. Third, I will scrutinize the HCJ's justification for building the wall to protect Jewish settlements in the West Bank. I will argue that constructing the wall to protect these settlements violates fundamental principles of international law as delineated in the ICJ opinion, and that the HCJ ignored other options for protecting the lives of Jewish settlers. Finally, I will argue that the HCJ willfully ignored the real motive behind the wall's construction, to create facts facilitating Israel's illegal annexation of Palestinian land. The HCJ not only has rationalized the violation of a basic principle of the United Nations Charter but has in effect become an accessory to the crime. Reconciling Irreconcilables 229. 1. The International Court of Justice Advisory Opinion on July 9, 2004, the International Court of Justice, ICJ, rendered its advisory opinion in response to this request of the United Nations General Assembly. What are the legal consequences arising from the construction of the wall being built by Israel, the occupying power, in the occupied Palestinian territory, including in and around East Jerusalem, as described in the report of the Secretary General, considering the rules and principles of international law, including the Fourth Geneva Convention of 1949, and relevant Security Council and General Assembly resolutions. 5. The opinion dealt with many issues, including whether the ICJ had jurisdiction to give the advisory, whether prudentially the ICJ should have interposed itself in this dispute, as well as the legal ramifications for Israel and the international community of the ICJ's conclusions. I will focus strictly on the ICJ's ending regarding the legality of the wall. It nonetheless merits notice that the court also deliberated on whether the proper terminology was fence, barrier, or wall. Noting the inadequacies of each term, the court elected to use the terminology employed by the General Assembly, Para 67, hence, following the court, the adoption of wall in this chapter as well. Legal framework. The ICJRST sets out the legal framework of rules and principles of international law for assessing the legality of the wall. At the head of the list it puts the principle, derived from Article 2 of the United Nations Charter and explicitly adopted by the General Assembly in 1970, that no territorial acquisition resulting from the threat or use of force shall be recognized as legal, Para 87, cf. Paras 74 to 75, 117, where the illegality of Israel's annexation of East Jerusalem is also recalled. Regarding international humanitarian law or the general laws and customs of war, the ICJ points to the applicability of the Hague Regulations of 1907, and although Israel disputes this, the Fourth Geneva Convention of 1949, Paras 89 to 101, citing inter alia the consensus of international opinion on the applicability of the Fourth Geneva Convention to the occupied Palestinian territory. The court also NDS again, despite Israeli objection that the international human rights covenants to which Israel is party apply within the occupied Palestinian territory, Paras 102 to 13, citing inter alia the authoritative opinion of the UN Human Rights Committee. The factual data on which the ICJ bases its opinion derive from a voluminous dossier assembled by the UN Secretary General documenting the wall's construction and its impact on the Palestinian population, as well as from the written submissions of numerous participants in the proceedings, Para 57. Although Israel's submission to the ICJ was limited to issues of jurisdiction and judicial propriety, it refused to cooperate in the proceedings beyond this point. The court NDS that it has before it sufficient information and evidence to enable it to give the advisory opinion, Para 58. ICJ Findings 6. Locating its RST ending in the UN Charter principle that prohibits the acquisition of territory by war, the ICJ observes that it is apparent that the wall's sinuous route has been traced in such a way as to include within the Israeli side the great majority of the Israeli settlements in the occupied Palestinian territory, including East Jerusalem. The ICJ next recalls the UN Security Council's endings that, based on Article 49 of the Fourth Geneva Convention, these settlements have no legal validity, March 1979, July 1979, and constitute a flagrant violation of international law, March 1980. 7. On this crucial point the court concludes that Israeli settlements in the occupied Palestinian territory, including East Jerusalem, have been established in breach of international law, Paras 119 to 20, cf. Para 99. Finally, the ICJ voices concern that, rather than being provisional in nature, the wall might be designed to annex Palestinian land on which the settlements are built, thereby violating both the UN Charter and the Fourth Geneva Convention, whilst the court notes the assurance given by Israel that the construction of the wall does not amount to annexation and that the wall is of a temporary nature. It nevertheless cannot remain indifferent to certain fears expressed to it that the route of the wall will prejudge the future frontier between Israel and Palestine, and the fear that Israel may integrate the settlements and their means of access. The court considers that the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case, and notwithstanding the formal characterization of the wall by Israel, it would be tantamount to de facto annexation. In other terms, the route chosen for the wall gives expression in loco to the illegal measures taken by Israel with regard to Jerusalem and the settlements, as deplored by the Security Council. Para 121-22. The ICJ opinion also considers the wall's construction in light of other provisions of international humanitarian law, specifically the Hague Regulations Articles 43, occupants' responsibility to ensure public order, 46, obligation that private property be respected, and 52, conditional right of requisitions in kind and services for the army of occupation. The Fourth Geneva Convention Articles 47, protected persons who are in occupied territory shall not be deprived of the benefits of the present convention by any agreement between the authorities of the occupied territories and the occupying power. 49, prohibition on population transfer and deportation to or from occupied territory, except temporary evacuation of the occupied population for the security of the population or imperative military reasons. 52, prohibition on all measures aiming at creating unemployment. 53, prohibition on any destruction of property, except when such destruction is rendered absolutely necessary by military operations. In addition, the ICJ cites the human rights protections of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, regarding the right to freedom of movement as well as the right to work, health, education, and an adequate standard of living. Paras 123-31. The ICJ NDS that construction of the wall has led to the destruction or requisition of properties under conditions that violate Articles 46 and 52 of the Hague Regulations and Article 53 of the Fourth Geneva Convention. It also has imposed substantial restrictions on the freedom of movement, had serious repercussions for agricultural production, and led to increasing difficulties regarding access to health services, educational establishments, and primary sources of water, in violation of international human rights law. Furthermore, the court found that since a significant number of Palestinians have already been compelled by the construction of the wall and its associated regime to depart from certain areas, a process that will continue as more of the wall is built, that construction, coupled with the establishment of the Israeli settlements, is tending to alter the demographic composition of the occupied Palestinian territory, in violation of Article 49 of the Fourth Geneva Convention, Paras 132-34. The court next considers the special allowances international humanitarian law makes for military exigencies. It NDS that Article 46 of the Hague Regulations, private property must be respected, and Article 47 of the Fourth Geneva Convention, agreements signed under occupation cannot annul the Convention's protections, are absolute, as is the prohibition in Article 49 of the Fourth Geneva Convention on the occupying power settling its civilian population in occupied territory. Although Article 53 of the Fourth Geneva Convention allows for the destruction of property rendered absolutely necessary by military operations, the court was not convinced that the destruction wrought by the wall was unavoidable. In addition, the court NDS that, although human rights law also contains qualifying clauses, the exceptional circumstances under which these clauses apply are not met in the present instance. Paras 135-36. Reconciling irreconcilables 233. The ICJ concludes that neither the wall nor the attendant violations of Palestinian rights can be justified on grounds of military necessity. The court, from the material available to it, is not convinced that the specific course Israel has chosen for the wall was necessary to attain its security objectives. The wall, along the route chosen, and its associated regime gravely infringe a number of rights of Palestinians residing in the territory occupied by Israel, and the infringements resulting from that route cannot be justified by military exigencies or by the requirements of national security or public order. The construction of such a wall accordingly constitutes breaches by Israel of various of its obligations under the applicable international humanitarian law and human rights instruments. Para 137. THE Court is not convinced that the construction of the wall along the route chosen was the only means to safeguard the interest of Israel against the peril which it has invoked as justification for that construction. Para 140. Cf. Paras 141-42. The ICJ voted 14-1, with Judge Bjurgenthal from the United States as the lone dissenter, that construction of the wall being built by Israel, the occupying power, in the occupied Palestinian territory, including in and around East Jerusalem, and its associated regime, are contrary to international law. Separate ICJ opinions. Fully 6 of the judges voting with the majority on the court issued separate opinions. Whereas several of these judges were critical, sometimes harshly, of aspects of the majority opinion, they nonetheless concurred on its fundamental ending that the wall was illegal. Judges Higgins, Awada, and Kuijmans all criticize the majority opinion for lack of balance, and they lament the paucity of data submitted supporting the Israeli position. 9. Nonetheless, Higgins concurs that Israel violated those provisions of humanitarian law cited in the majority opinion, that while the wall does seem to have resulted in a diminution on sick attacks on Israeli civilians, the necessity and proportionality for the route selected, with its attendant hardships for Palestinians uninvolved in these attacks, has not been explained, and that there is undoubtedly a significant negative impact upon portions of the population of the West Bank, that cannot be excused on the grounds of military necessity. And nor has Israel explained to the United Nations or to this court why its legitimate security needs can be met only by the route selected. Separate opinion of Judge Higgins, Paras 24, 35, 40. Similarly, Judge Awada observes that it would seem reasonable to conclude on balance that the political, social, economic, and humanitarian impacts of the construction of the wall, as substantiated by ample evidence supplied and documented in the course of the present proceedings, is such that the construction of the wall would constitute a violation of international obligations, and that these impacts are so overwhelming that I am ready to accept that no justification based on the military exigencies, even if afforded by substantiated facts, could conceivably constitute a valid basis for precluding the wrongfulness of the act on the basis of the stringent conditions of proportionality, and that even if it were true that Israel's sole purpose in building the wall was to combat terrorist attacks, it would not be a sufficient ground for justifying the construction of the wall as it has actually been drawn up and implemented. Separate opinion of Judge Awada, Paras 22-24. Finally, Judge Kuijman states that THE Court is right when it concludes that the available material allows it to give the opinion, that Israel by constructing the wall and establishing the associated regime has breached its obligation under international humanitarian and human rights law, that the court's concern that the construction of the wall creates a fait accompli is legitimate, that the conditions set out in the qualifying clauses in the applicable humanitarian law and human rights law conventions have not been met, and that the measures taken by Israel cannot be justified by military exigencies or by requirements of national security or public order, and that, although the ICJ should have put construction of the wall to the proportionality test, it would nonetheless have failed the test, because the ensuing disturbing consequences for the inhabitants of the occupied Palestinian territory are manifestly disproportionate to interests which Israel seeks to protect. Paras 28-30, 34. It remains to consider Judge Bjurgenthal's sole negative vote on the ending that the wall was illegal. Bjurgenthal did not lay a dissenting opinion but rather what he called a declaration, in which he is at pains to stress that there is much in the advisory opinion with which I agree. Nonetheless, Bjurgenthal maintains that the ICJ should not have rendered the requested opinion, and that the court did not have before it the requisite factual basis for its sweeping endings. Declaration of Judge Bjurgenthal, Para 1. On the latter point, he specifically argues that, regarding Israel's legitimate security concerns, the court didn't have sufficient information to make an accurate assessment, didn't give Israel's submission sufficient consideration, and didn't provide an adequate account of its own reasoning. Instead, all we have from the court is a description of the harm the wall is causing and a discussion of various provisions of international humanitarian law and human rights instruments, followed by the conclusion that this law has been violated. Lacking is an examination of the facts that might show why the alleged defenses of military exigencies, national security, or public order are not applicable to the wall as a whole or to the individual segments of its route. The court says that it is not convinced, but it fails to demonstrate why it is not convinced, and that is where these conclusions are not convincing. Declaration, Paras 3, 7. As an alternative to the approach of the ICJ majority and without prejudging the outcome of it, Bjergenthal recommends, RST, assessing whether Israel's right of self-defense can be legitimately invoked against the terrorist attacks. Second, assessing whether the wall is a necessary and proportionate response to these attacks. And third, applying these tests in a segment-by-segment scrutiny of the wall's legality. Declaration, Para 5. On these points as well as many others in his statement, Bjergenthal takes the identical position as the Israel High Court. There's one crucial exception, however. He explicitly declares the Jewish settlements and 236 postscript. Concomitantly, any means to preserve and protect them, illegal under international law, paragraph 6 of Article 49 of the Fourth Geneva Convention. Does not admit for exceptions on grounds of military or security exigencies. It provided that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. I agree that this provision applies to the Israeli settlements in the West Bank and that their existence violates Article 49, paragraph 6. It follows that the segments of the wall being built by Israel to protect the settlements are ipso facto in violation of international humanitarian law. Para 9, emphasis added. This last sentence delivers a crushing blow to the Israel High Court's defense of the wall. Not even the declaration of the American judge can rescue it. First Israel High Court judgment on the wall. The Israel High Court of Justice, HCJ, has rendered two principled opinions bearing on the wall, one shortly before the ICJ decision and one a year after it. Each opinion dealt with the legality of a different segment of the wall. The RST judgment was delivered on June 30, 2004, addressing this question. The commander of the IDF forces in Judea and Samaria issued orders to take possession of plots of land in the area of Judea and Samaria. The purpose of the seizure was to erect a separation fence on the land. The question before us is whether the orders and the fence are legal. 10. Although the HCJ occasionally blurs the distinction, this RST judgment treats the wall mainly as a means of preventing the passage of Palestinians into the State of Israel, and not as in the second judgment as a means of protecting Jewish settlements in the West Bank, Para 3, but cf. Paras 12, 29. Sociopolitical context. The court RST sketches the sociopolitical context of its judgment in lengthy, emotive paragraphs chronicling the Palestinian terror attacks to which Israel has been subject since September 2000. For example, Reconciling Irreconcilables 237. They are directed against citizens and soldiers, men and women, elderly and infants, regular citizens and publickers. Terror attacks are carried out everywhere, in public transportation, in shopping centers and markets, in coffee houses and in restaurants. The penultimate sentence of the second paragraph makes passing reference that the armed conflict has left many dead and wounded on the Palestinian side as well, only to be followed by yet more paragraphs deploring the Palestinian terrorists, terrorist infrastructure, and terror acts. The court points to these Palestinian terror attacks as the background behind the decision to construct the separation fence. In the Judea and Samaria area, which would make it difficult for terrorists to strike at Israelis and ease the security forces' struggles against the terrorists, Paras 1-3. Appraisal. The court's account of the Second Intifada omits mention that Palestinians did not resort to terrorist attacks until after Israel had used massive, lethal, and indiscriminate repower to quell largely nonviolent demonstrations, that fully 3 times as many Palestinians as Israelis were killed during the Second Intifada, and that, apart from the casualties on both sides, all the victims of the manifold human rights violations documented by human rights organizations, house demolitions, torture, political liquidations, arbitrary detentions, prolonged curfews, denial of medical care were Palestinian. 11. It might be argued that, in the context of adjudicating the legality of constructing a wall to ward off terrorist attacks, Palestinian suffering, however real, is beside the point. Yet, apart from such an omission radically distorting the overall context, if the root cause of Palestinian attacks is this brutal Israeli occupation, then, arguably, one alternative to constructing a wall is ending the occupation, especially if the wall will further brutalize the affected population, provoking yet more attacks. By situating the state's decision to build the wall solely in the context of Palestinian terror attacks and by ignoring the state's long-standing territorial ambitions, the court also preempts consideration that the real purpose of the wall might not be military security but, rather, political, the terror attacks serving as a pretext for annexation of West Bank land. Rejection of petitioners' claims. The petitioners from Beit Zorik and other Palestinian villages challenge the wall's route on the grounds of the massive, disproportionate harm it will inflict on them and the violation of their fundamental rights under international law attending its construction, as well as because the security arguments disguise the real objective, the annexation of areas to Israel, paras 9-11. Apart from Palestinian petitioners, the Nonpartisan Council for Peace and Security, comprised of high-ranking Israel Reserve officers having background in security, also submitted a serious and grave affidavit stating that, although it supports a separation fence as a solution to Israel's security needs, the proposed route encroaching on West Bank territory is not only unnecessary from a military perspective, but actually exacerbates Israel's security problems, Para 16-19, cf. Para 54. Finally, residents of the Israeli town of Mevaseret Zion, which is adjacent to the Beit Zorik village, likewise petitioned that the fence route should be immediately adjacent to the Green Line, on the grounds that the wall's route inflicts undue injury on Palestinian villagers, who, on its account, have already turned from a tranquil population into a hostile one, Para 22, cf. Para 69, one resident of Mevaseret Zion supported the proposed route. Taking as its departure point that Israel holds the area in belligerent occupation, the HCJ cites the Hague Regulations and the Fourth Geneva Convention, alongside Israeli administrative law, as the relevant normative framework, Paras 23-24. 12. It NDS that the fence is motivated by security reasons. To support its conclusion, the court adduces this evidence. The government has emphasized numerous times that it is a security measure, not a political border. The commander of the IDF forces of Judea and Samaria submitted an affidavit stating that the objective of the security fence is to help contend with the threat of Palestinian terror. In an additional affidavit, the commander attested that it is not a permanent fence, but rather a temporary fence erected for security needs. The HCJ opines that we have no reason not to give this testimony of the commander less than full weight, and we have no reason not to believe the sincerity of the commander, Paras 28-29. Rejecting petitioners' claims that the real objective of the Israeli government was annexing land and that if the fence was primarily motivated by security considerations, it would be constructed on the Green Line, i.e., Israel's pre-June 1967 border, the court stated, "We have no reason to assume that the objective is political rather than security-based." Indeed, petitioners did not carry the burden and did not persuade us that the considerations behind the construction of the separation fence are political rather than security-based. Similarly, petitioners did not carry their burden, and did not persuade us that the considerations of the commander of the IDF forces in the area, in choosing the route of the separation fence, are not military considerations, and that he has not acted to fool them in good faith, according to his best military understanding. Para 31. In addition, citing Articles 23, g, and 52 of the Hague Regulations and Article 53 of the Fourth Geneva Convention, it NDS that the seizure of Palestinian land along the wall's route is legal. The military commander is authorized by the international law applicable to an area under belligerent occupation to take possession of land, if this is necessary for the needs of the army. He must, of course, provide compensation for his use of the land. The military commander must consider the needs of the local population. Assuming that this condition is met, there is no doubt that the military commander is authorized to take possession of land in areas under his control. The construction of the separation fence falls within this framework. The infringement of property rights is insufficient, in and of itself, to take away the authority to build it. It is permitted, by the international law applicable to an area under belligerent occupation, to take possession of an individual's land in order to erect the separation fence upon it, on condition that this is necessitated by military needs. To the extent that construction of the fence is a military necessity, it is permitted, therefore, by international law. Indeed, the obstacle is intended to take the place of combat military operations, by physically blocking terrorist infiltration into Israeli population centers. Para 32. 240 Postscript. Appraisal. Apart from adducing the avowals of the military echelon of Prime Minister Sharon's government, which are credited at face value, the HCJ never stated why it was convinced that the purpose of the wall was security, or why petitioners failed to convince that its real purpose was to annex land. Likewise, it never demonstrated the military necessity upon which it justified seizure of private Palestinian land. In fact, as becomes plain further on in the judgment, petitioners literally couldn't persuade the HCJ that the wall's route was motivated by political rather than military security considerations. For the court's bedrock position was that, lacking competence to judge in security matters, it deferred entirely to the state's military echelon, whereas its domain was assessing the legality of the military's recommendation. The route of the wall, it stated, raises problems within the realm of military expertise. We, justices of the Supreme Court, are not experts in military affairs. We shall not examine whether the military commander's military opinion corresponds to ours. So we act in all questions which are matters of professional expertise, and so we act in military affairs as well. And quoting from a prior judgment again. In exercising judicial review, we do not turn ourselves into experts in security affairs. We shall not substitute the discretion of the commander with our own discretion. We shall check the legality of the discretion of the military commander and ensure that his decisions fall within the zone of reasonableness. Para 46. The impossible burden put on petitioners to disprove the government's contention of military necessity is pointed up by the court's treatment of the affidavit submitted by the Council for Peace and Security, composed of Israeli reserve officers challenging the military necessity of the route chosen for the wall. It wasn't disputed that the council members possessed the requisite competence and information to judge in this matter, and, unlike the military echelon subordinate to the Sharon government, these high-level Israeli officers weren't subject to direct political pressures. Yet the position of the court was that when in doubt, credit the state, not its critics. The petition before us is exceptional, the court wrote, in that opinions were submitted by the Council for Peace and Security. These opinions deal with the military aspect of the separation fence. They were given by experts in the military and security fields, whose expertise was also recognized by the commander of the area. We stand, therefore, before contradictory military opinions regarding the military aspects of the route of the separation fence. These opinions are based upon contradictory military views. In this state of affairs, are we at liberty to adopt the opinion of the Council for Peace and Security? Our answer is negative. At the foundation of this approach is our long-held view that we must grant special weight to the military opinion of the official who is responsible for security. Para 47. Given the mutual balancing of judgments by military experts for and against the wall's route, and, given the massive harm the Palestinians will suffer due to the wall's construction, on which all sides agree, and given that the wall's route was determined by an openly annexationist prime minister and his hawkish defense minister, 13, and, given the prima facie bias of the military commander responsible for security but also subordinate to the ministerial architects of the wall as against the acknowledged expertise but also apparent nonpartisanship of high-ranking former military and intelligence personnel on the council, it would seem that the skeptical testimony of the council would put a crushing burden on the government to prove its case of military necessity. The contrary position of the court underscores the peculiarity of its locution that petitioners did not carry the burden and did not persuade. For it appears that the quality and quantity of petitioners' evidence are of no account, the state's position automatically takes precedence. 14. Indeed, the court's resolve to defer to the state on the wall's route couldn't even be shaken by opposition of residents of the Israeli community adjacent to Beit Zorik and, accordingly, on the front line in the event of a terrorist attack. An equally perplexing statement of the court is this: we are dealing with two military approaches. Each of them has military advantages and disadvantages. In this state of affairs, we must place the expert opinion of the military commander at the foundation of our decision. Para 47. If each of these respective military approaches has both advantages and disadvantages, and in light of Israel's hotly contested right to construct a wall in the West Bank, shouldn't the tipping factor be not which approach is supported by the military commander currently in charge but which approach inflicts less harm on the affected population in the case at hand, limited harm versus massive harm? Finally, notice must be taken of the contradictions in which the court gets tangled. On the one hand, it affirms the state's position that the wall's route was determined exclusively by the operational security consideration, Para 12, and that great weight was given by the state to the interests of the residents in the area, in order to minimize, to the extent possible, the injury to them, Para 13. 15. On the other hand, it points up the state's willingness, in the course of trial deliberations, to allow changes in part of the route, Para 16, cf. Paras 50, 53, 64, 70, making the wall less encroaching on the West Bank. In fact, as seen presently, the court will order the state to modify the wall's route yet further insofar as its proposed course cannot be justified on strictly operational security grounds. Does this not suggest that the state's original route for the wall was based on more than operational security exigencies alone, and shouldn't such a ending have called into question the good faith that the court has uncritically invested in the intentions of the wall's proponents? 16. Applying the proportionality test. Having convinced itself of the wall's military necessity, the court proceeds to assess whether it can be legally justified. It nds that the legal ity of the wall must be judged on whether it properly balances human rights and the needs of the local population, on the one hand, and security needs from the perspective of the military commander, on the other. To test whether this balance is effected, the court proposes using the principle of proportionality, according to which the liberty of the individual can be limited, in this case, the liberty of the local inhabitants under belligerent occupation, on the condition that the restriction is proportionate, Para 36. Specifically, the court examines the legality of the wall by subjecting it to a cumulative three-pronged test. 1. The means used to achieve the stated objective must be rational or appropriate. 2. The means used to achieve the stated objective must be least injurious. 3. The damage caused by the means used to achieve the stated objective must be proportionate to the gain brought about by that means. Paras 41 to 42. The court nds that condition, 1, has been met by virtue of the court's very ruling that the wall constitutes a military necessity, Para 57, and condition, 2, has been met by virtue of the state's avowal, and our very determination that we shall not intervene in that position, that it is the least injurious means to prevent terrorist attacks, Para 58. However, the court nds that condition, 3, has not been met, and recommends an alternative route to the one proposed by the state, our answer is that the relationship between the injury to the local inhabitants and the security net from the construction of the separation fence along the route, as determined by the military commander, is not proportionate. The route undermines the delicate balance between the obligation of the military commander to preserve security and his obligation to provide for the needs of the local population. This approach is based on the fact that the route which the military commander established for the security fence which separates the local inhabitants from their agricultural lands injures the local inhabitants in a severe and acute way, while violating their rights under humanitarian international law. 244 Postscript. Pages 56 to 58, 60, 77, 100, and 56 to 57, 200, and Isabel Kirshner, Barrier, The Seam of the Israeli-Palestinian Conflict, New York, 2005, pages 18, 63 to 64, 110. These injuries are not proportionate. They can be substantially decreased by an alternate route, either the route presented by the experts of the Council for Peace and Security, or another route set out by the military commander. Such an alternate route exists. It is not figment of the imagination. The military commander's choice of the route of the separation fence is disproportionate. The gap between the security provided by the military commander's approach and the security provided by the alternate route is minute, as compared to the large difference between a fence that separates the local inhabitants from their lands, and a fence which does not separate the two, or which creates a separation which is smaller and possible to live with. Paras 60 to 61, 17. There is no escaping, the court concludes, a renewed examination of the route of the fence, according to the standards of proportionality that we have set out, Para 85. Appraisal. Unlike the ICJ, which found that the wall violated absolute principles of international law and that the extenuations of military necessity didn't apply in this instance, the HCJ started from the premise that no absolute principles had been violated and the relevant standard was proportionality. 18. It claimed to apply a three-prong proportionality test, but the RST and second prongs uncritically reiterated the position of the state. The wall's route was rational and least injurious because the state said so. Inasmuch as the results of these tests were decided a priori and irrespective of the evidence adduced, the court seems to have confused test administering with rubber stamping. 19. Moreover, on the least injurious test, the court ignored alternative options proposed by human rights organizations for averting terrorist attacks, such as being up the hitherto lax security measures at Israeli checkpoints, through which most of the suicide bombers have entered Israel, and bolstering the Israeli military presence along the Green Line, protection of which has been a low priority for the IDF. 20. The court's negative ending in the third subtest poses yet new problems. The state had argued that the proposed route of the wall was least injurious to the local population while still protecting Israel's vital security interests. In the third subtest, the HCJ maintained that Israel's vital security interests could still be protected while rerouting the wall so that less injury was inflicted on the local population. But doesn't this mean that, although the court attested that the state satisfied the second prong of proportionality, least injurious, by the court's own ending in the third subtest it didn't? The court's point of departure was that it would not second-guess the expertise of the military commander. Yet, by maintaining in the third subtest that were the wall rerouted Israel's net loss in security would be marginal and, tacitly, its vital interests still protected, wasn't the court doing just that? The court maintained in the third subtest that, in lieu of the state's proposed route, the alternative routings proposed by the Council for Peace and Security should be considered. But why then did the court automatically defer to the state as against the Council on the military necessity of the wall's original route, and subtest 1 on its rationality? In deciding on the wall's military necessity, rationality, and least injuriousness, the court reflexively deferred to the expertise of the state's military commander, even privileging this expertise over that of the military officers in the Council for Peace and Security. Yet in applying the third subtest, the court disputed this expertise, even siding with the Council for Peace and Security. The court's negative finding in the third prong of the proportionality test contradicted all its prior positive findings on the necessity, rationality, and least injuriousness of the wall. Finally, although ordering a few kilometers of the wall to be rerouted, the court nonetheless affirmed that a wall deeply encroaching on the West Bank was legal under international law. Far from being dealt a political blow, the state scored a resounding victory in this case. 3. Second Israel High Court Judgment on the Wall. The Second Israel High Court judgment was rendered on September 15, 2005, addressing this question. Al-Menashe is an Israeli town in the Samaria area. It was established approximately 4 kilometers beyond the Green Line. Pursuant to the military commander's orders, a separation fence was built, surrounding the town from all sides, and leaving a passage containing a road connecting the town to Israel. A number of Palestinian villages are included within the fence's perimeter. The separation fence cuts them off from the remaining parts of the Judea and Samaria area. An enclave of Palestinian villages on the Israeli side of the fence has been created. Petitioners are residents of the villages. They contend that the separation fence is not legal. Is the separation fence legal? 21. This court judgment is divided into VE parts. Because it's RST2 parts, the relevant legal framework and the Beitzoerich case go over some ground already covered in our prior discussion. I will consider only the new elements in the court's judgment. I will then consider the last 3 parts of the judgment, in which the court evaluates the ICJ opinion, the repercussions of the ICJ opinion for its ruling in the Beitzoerich case, and the legality of the wall incorporating the Al-Menashe enclave. Incorporating the Jewish settlements. A novelty of the Second High Court case is that it directly confronts the legality of the wall to protect not Israel proper but illegal Jewish settlements in occupied Palestinian territory such as Al-Menashe. Does the military commander's authority to construct a separation fence also include his authority to construct a fence in order to protect the lives and safety of Israelis living in Israeli communities in the Judea and Samaria area? Para 18. The court responds that in our opinion, the answer is positive. It grounds this ending in both international and Israeli law. The Hague Regulations. Article 43 gives the military commander authority to ensure public order and safety. The court infers from this authority that the military commander must preserve the safety of every person present in the area of belligerent occupation and, accordingly, is authorized to construct a separation fence in the area for the purpose of defending the lives and safety of the Israeli settlers in the area. Paras 18-19. The court is as emphatic as it is passionate that this authority obtains regardless of the settlement's legal status. It is not relevant whatsoever to this conclusion to examine whether the settlement activity conforms to international law or does it, as determined in the advisory opinion of the International Court of Justice at The Hague. The authority to construct a security fence for the purpose of defending the lives and safety of Israeli settlers is derived from the need to preserve public order and safety. It is called for, in light of the human dignity of every human individual. It is intended to preserve the life of every person created in God's image. The life of a person who is in the area illegally is not up for the taking. Even if a person is located in the area illegally, he is not outlawed. Para 19. Lending further weight to this conclusion, the court recalls from its prior judgments and the Oslo Accords the indeterminate legal status of the settlements. Their legality will be determined in the peace treaties which the relevant parties will reach. The status of the settlements will be determined in the peace treaty. The question of the Israeli settlements in the area will be discussed in the negotiations over the null status. Paras 19-20. Internal Israeli law. The settlers are Israeli citizens. The court infers from this legal status that the military authority is bound to protect all their citizenship rights, t.e. constitutional rights which are basic laws and are common law grant to every person in Israel are also granted to Israelis who are located in territory under belligerent occupation which is under Israeli control. Israelis present in the area have the rights to life, dignity and honor, property, privacy, and the rest of the rights which anyone present in Israel enjoys. However, The court then enters the caveat that the precise scope and level of protection to which settlers are entitled differs from that of Israelis living in Israel due to the fact that the area is not part of the State of Israel but, rather, a regime of belligerent occupation, paras 21-22. 248 Postscript. Appraisal. The court maintains that, in light of the military's authority to protect the lives and safety of Israeli settlers, construction of the wall around Israeli settlements can be justified regardless of the legal status of the settlements. The wall serves the dual function, however, both of protecting the lives and safety of the settlers and of protecting their lives and safety as settlers living in the West Bank. The position of the court might be tenable were the wall the only means available to safeguard settlers, defense of their lives being, as it were, inseparable from defense of their living as settlers. But the lives and safety of the West Bank settlers can equally be protected by evacuating them to Israel. If the wall protects both settlers and settlements whereas repatriation can just as well protect settlers but not settlements, the safety of settlers is a red herring and the legality of settlements is dispositive, illegal settlements, illegal wall. Thus, having concurred in his ICJ declaration that Israeli settlements violate Article 49 of the Fourth Geneva Convention, Judge Björgenthal concludes, the segments of the wall being built by Israel to protect the settlements are ipso facto in violation of international humanitarian law. 22 The principle at stake would seem to be uncontroversial. If a squatter comes under assault from the property owner, the law would kick in to protect his life and safety, but it would be a peculiar judicial decision indeed that would uphold the squatter's right, in the name of his human dignity and creation in God's image, to construct a wall around his illegally occupied parcel of land, further encroaching on the owner's property and thereby allowing the squatter to reap advantage from his own wrong. Rather than compound one injury against the property owner by another, isn't it obvious that the judge would protect the squatter by having him escorted off the premises he's illegally occupying? 23 One might argue that the court did not propose evacuation because it wasn't a feasible option. Yet not having canvassed the state or military authority on repatriation, the judgment makes no mention of it in the West Bank context. On the court's own terms of lacking competence in strategic military matters, it couldn't have ruled out this option on feasibility grounds. Finally, this option could hardly have escaped the court's notice. Evacuation of the Gazan settlers, in accordance with the Gaza disengagement plan, was occurring just as the court deliberated on this case. In silently passing over the option of evacuation, and under the holy cloak of protecting the settlers' human dignity and creation in God's image, it would appear that the court made, on its own initiative and in its autonomous capacity, the profane decision to protect the illegal settlements as well. To justify construction of the wall around the settlements, the court further points to their allegedly indeterminate legal status. But if the allegedly indeterminate legal status of the settlements justifies the wall's construction, how can it be that the settlement's legal status is not relevant whatsoever to the wall's legality? On the contrary, the logical correlative of the court's argument would seem to be, if the legal status of the settlements is decided, it would be supremely relevant to the wall's legality. In fact, the ICJ, alongside every other authoritative international body, has determined that the settlements are illegal. From this ending, and on the basis of the High Court's own reasoning, it ensues that if Israel is building the wall to protect illegal settlements, the wall is ipso facto, Björgenthal, illegal as well. The Oslo Accords cannot be used to trump the international consensus on the settlement's illegality. On the one hand, the Accords explicitly do not speak on questions of legality 24 while, on the other, Article 47 of the Fourth Geneva Convention, cited by the ICJ, states that protected persons who are in occupied territory shall not be deprived of the benefits of the present convention by any agreement between the authorities of the occupied territories and the occupying power. Invoking internal Israeli law to justify construction of a wall protecting Israeli citizens resident in the West Bank is just as problematic. The court initially maintains that West Bank settlers, being Israeli citizens, have rights identical to those of Israeli citizens living inside the Green Line, which the state is duty-bound to protect. But the relevant eld of a citizen's rights is bounded by the state's territorial borders, while the state's protection of its citizens abroad is proscribed by international law and interstate treaty. To claim that Israelis present in the area have all the same rights anyone present in Israel enjoys effectively annexes the occupied Palestinian territory to Israel. It also effectively grounds the right of settlers to reside in these territories, if a basic right of citizenship is the right of place, and if an Israeli settler resident in the West Bank has rights identical to those of an Israeli living inside the Green Line, then a settler's right of place in the West Bank must be on par with an Israeli citizen's right of place inside the Green Line. The court has accordingly lent legitimacy to the settlements, even if it maintains elsewhere that their legal status is indeterminate, and international opinion has uniformly declared them illegal. No doubt aware of these insoluble contradictions, the court proceeds to temper its sweeping pronouncements. The scope and level of rights to which the settlers can lay claim, and which the state is bound to protect, differ from those of an Israeli citizen living inside Israel insofar as the area is not part of Israel, and not subject to Israeli law but the law of belligerent occupation. But, then, the settlers cannot possess rights proscribed by relevant international law. Because this body of law speaks unambiguously on the illegality of the settlements and, ipso facto, the illegality of the wall, Israel's internal law cannot justify construction of the wall to protect the settlers. Confronting the ICJ opinion. After recounting the substance of the ICJ opinion, the High Court proceeds to juxtapose their respective conclusions. It purports that the ICJ and HCJ share a common normative legal framework. The ICJ held that Israel holds the West Bank, Judea and Samaria, pursuant to the law of belligerent occupation. That is also the legal view at the base of the Beit Zoharic case. The ICJ held that an occupier state is not permitted to annex the occupied territory. That was also the position of the court in the Beit Zoharic case. The ICJ held that in an occupied territory, the occupier state must act according to the Hague Regulations and the Fourth Geneva Convention. That too was the assumption of the court in the Beit Zoharic case, although the question of the force of the Fourth Geneva Convention was not decided, in light of the state's declaration that it shall act in accordance with the humanitarian part of that convention. The ICJ determined that in addition to the humanitarian law, the conventions on human rights apply in the occupied territory. This question did not arise in the Beit Zoharic case. For the purposes of our judgment in this case, we assume that these conventions indeed apply. The ICJ held that the legality of the wall, the fence in our nomenclature, shall be determined, inter alia, by Regulations 46 and 52 of the Hague Regulations and 53 of the Fourth Geneva Convention. This was also the position of the Supreme Court in the Beit Zoharic case. The ICJ held that as a result of the building of the wall, a number of rights of the Palestinian residents were impeded. The Supreme Court in the Beit Zoharic case also held that a number of human rights of the Palestinian residents had been impeded by the building of the fence. Finally, the ICJ held that the harm to the Palestinian residents would not violate international law if the harm was caused as a result of military necessity, national security requirements, or public order. That was also the approach of the court in the Beit Zoharic case. Para 57. Finding no substantive disagreement in their respective legal frameworks, the court concludes, the main difference between the two judgments stems primarily from the difference in the factual basis upon which each court made its decision. Once again, the simple truth is proven, the facts lie at the foundation of the law, and the law arises from the facts, ex facto jus oritur. Para 61. Appraisal. One notes a pair of glaring omissions in the court's seemingly exhaustive inventory of common legal principles. 252 Postscript. In its opinion, the ICJ repeatedly cited the cardinal principle of international law of the inadmissibility of the acquisition of territory by force, 25 while in foolement of the Palestinian people's right to self-determination, designating the West Bank, including East Jerusalem, and Gaza as occupied Palestinian territory. 26. It thereby explicitly affirmed that Israel has no legitimate title to any of these territories. In the Beit Zoharic case, however, the High Court states only that it is not within the purview of the military commander to redraw Israel's borders. The military commander cannot order the construction of the separation fence if his reasons are motivated by a desire to annex territories to the State of Israel, HCJI, Parad 27. Unlike the ICJ, it fails to establish that Israel has no legitimate claim on this territory, the sovereignty of which has been definitively resolved. This crucial difference tinctures every aspect of their respective judgments. Whereas the ICJ uniformly refers to the West Bank as occupied Palestinian territory, the High Court rather refers to Judea and Samaria, or, treating it as Terran Elias, the area. 27. A wall the root of which deeply encroaches on another people's sovereign territory plainly casts a different shadow than a wall the root of which merely traverses a no man's land or even one's own. In multiple places the ICJ highlights the illegality of the Jewish settlements. But in the High Court's enumeration of the ICJ's normative principles, all of which the High Court supposedly holds in common, it omits mention of this fundamental ICJ ending, on which the High Court decidedly doesn't agree. 28. Indeed, it refers to illegal Jewish settlements benignly as Israeli communities in the Judea and Samaria area, Para 18, cf. Paras 1, 3. The case under High Court consideration hinges, however, on the legal status of the settlements. If Alpha Menashe is illegal, then the wall tracing a path around it is ipso facto illegal as well. Contrary to the High Court's conclusion, the ICJ and the High Court agree on the essential facts, more on which presently, but disagree on the normative framework. The simple truth is that the law, not the data, is dispositive in this case, reaffirming the wall's military necessity. Regarding the discrepant factual data, the High Court maintains that the RST difference, and the most important one between it and the ICJ, bears on the military necessity of the wall. The court RST recalls the broad spectrum of evidence it scrutinized in the Beit Zoharic case before concluding that the objective of the wall is security-based, not political. It goes on to fault the ICJ for the paucity of data it consulted and for giving Israel's case short shrift. The security military necessity is mentioned only most minimally in the sources upon which the ICJ based its opinion. In Israel's written statement to the ICJ, data regarding the terrorism and its repercussions, 254 postscript, were presented, but these did not end their way to the opinion itself. This minimal factual basis is manifest, of course, in the opinion itself. It contains no real mention of the security military aspect. In one of the paragraphs, the opinion notes that Israel argues that the objective of the wall is to allow an effective struggle against the terrorist attacks emanating from the West Bank. That's it. Para 63. Accordingly, although the ICJ was not convinced that the specific course Israel has chosen for the wall was necessary to attain its security objectives, Para 63, quoting from the advisory opinion, the High Court NDS that this ICJ conclusion was factually unfounded. We need not determine who is to blame for this severe oversight. Whatever the reason may be, the reality is that the ICJ based its opinion on a factual basis regarding impingement of Palestinian residents' rights without the factual basis regarding the security military justification for this impingement. In contrast, in the Beit Zoharic case, an expansive factual basis was laid before the court. Para 65, 29. Appraisal. According to the High Court, its conclusion that the wall's root constitutes a military necessity stands on a more evidentiary base than the ICJ's contrary conclusion. The court reached its determination, however, not on account of the solidity of the state's evidence but by yielding reexively to the authority of the military commander currently in charge. Indeed, not even the critical affidavit submitted by acknowledged Israeli military authorities could get the High Court to budge from this absolute deference to the state. The court faults the ICJ for not giving due consideration to the data Israel submitted on terrorism and its repercussions. But it is not the threat posed by terrorism that is at issue, rather, it is the necessity of building a wall that encroaches deeply into West Bank territory to impede it. To demonstrate that the reason behind the decision to erect the fence is a security consideration, the High Court subsequently adduces data and anecdotal evidence that the wall's construction has dramatically reduced terrorist attacks, which indicate the security importance of the fence and the security bonnet which results from its construction, paras 100 to 101. Leaving aside how much this reduction in suicide attacks was due to the wall as opposed to a new political configuration or other factors, 30 and leaving aside how much credibility to attach to state's evidence based on the interrogation of various terrorists, none of this data proves that rerouting the wall along the Green Line and evacuating the settlers couldn't have achieved the same objective. Deeming it a severe oversight, the court faults the ICJ for not more fully considering the military necessity of the wall. If, however, a wall the purpose of which is to protect illegal settlements ipso facto violates international law, it is hard to imagine what evidence could be adduced to justify the wall being built, whose sinuous route has been traced in such a way as to include the great majority of the Israeli settlements. The ICJ perhaps gave short shrift to the claim of military necessity not because of a severe oversight but because, prima facie, it was an impossible claim to sustain. Weighing the factual data. Beyond the ICJ's allegedly inadequate data on military necessity, the High Court cites factual inaccuracies in some data relied upon by the ICJ when assessing the damage wrought by the wall. The High Court claims that the difference between the factual bases upon which the courts relied is of decisive significance, for slight differences in the weight of the evidence can determine on which side the scale tips when applying the proportionality test. According to international law, the legality of the wall/fence route depends upon an appropriate balancing between security needs on the one hand and the impingement upon the rights of the local residents on the other. Delicate and sensitive balancing between the two sides of the scale brings about the appropriate solution. To illustrate these points, the court points to the case of the Palestinian town of Qalqiliyah. On one side of the scale, the ICJ placed the severe impingement of the rights of Palestinians in Qalqiliyah. Even if we remove the imprecision of these gers, i.e., the allegedly erroneous data relied upon by the ICJ, the remainder is sufficient to indicate a severe impingement of their rights. On the other side of the scale, the ICJ did not place due to the factual basis laid before it any data regarding the security and military considerations. It was not mentioned that Qalqiliyah lies 2 kilometers from the Israeli city of Kfar Saba, that Qalqiliyah served as a passage point to Israel for suicide bomber terrorists, that the Trans-Israel Highway, whose users must be protected, passes right by the city, that the majority of the fence route on the western side of the city runs on the Green Line, and part of it even within Israel, that since the fence around Qalqiliyah was built, terrorist infiltrations in that area have ceased. Para 68. The High Court also faults the data relied upon by the ICJ for its indiscriminateness. The information supplied to the ICJ didn't distinguish between the greater and lesser impacts of the wall along its route, compelling the ICJ to render judgment on the totality of the wall, whereas a differentiated approach, and using a proportionality test, would have shown that some segments of the wall pass legal muster while others do not. The material submitted to the ICJ contains no specific mention of the injury to the local population at each segment of the route, and contains no discussion of the security and military considerations behind the selection of the route, or of the process of rejecting various alternatives to it. These circumstances cast an unbearable task upon the ICJ. Thus, for example, expansive parts of the fence, approximately 153 kilometers of the 763 kilometers of the entire fence, which are approximately 20%, are adjacent to the Green Line, that is, less than 500 m away. An additional 135 km, which are 17.7% of the route, are within a distance of between 500 m and 2000 m from the Green Line. Between these parts of the route and the Green Line, there are no Palestinian communities, nor is there agricultural land. Nor are there Israeli communities in this area. The only reason for establishing the route beyond the green line is a professional reason related to topography, the ability to control the immediate surroundings, and other similar military reasons. Upon which rules of international law can it be said that such a route violates international law? Para 70. Appraisal. The thrust of this argument is that if the ICJ had at its disposal the accurate and discriminate factual data presented to the High Court, it wouldn't have pronounced the wall, or every section of it, illegal. 31. On multiple levels, however, this inference is problematic. It's not clear that the factual errors in the ICJ dossiers mattered much. 32. Thus, in the example on which it homed in, the High Court itself acknowledged that even if the allegedly erroneous ICJ data on Calcalia were corrected, the remainder is sufficient to indicate a severe impingement of Palestinian residents' rights. Moreover, the ICJ did not reach its conclusion after the relative quantitative weighing of evidence in a proportionality test, but rather after reaching the absolute qualitative ending that the wall couldn't be justified on grounds of military necessity and violated fundamental provisions of international law. 33. None of the alleged errors in the ICJ data affect its absolute qualitative endings. Yet, even if the proportionality test were applied, and on a segment-by-segment basis, it is still highly doubtful whether the wall, or parts of it, would pass legal muster. For example, applying its proportionality test to the wall segment enclosing Calcalia, the High Court justified the wall's construction by juxtaposing the severe impingements on its Palestinian residents against these allegedly countervailing military security factors. Calcalia lies 2 kilometers from the Israeli city of Kfar Saba. According to the court's second proportionality test, however, the means used to achieve the stated objective of preventing terrorist attacks must be the least injurious. Shouldn't the court then have to weigh the injury done by a wall enclosing Calcalia versus a wall enclosing Kfar Saba, either of which could obstruct terrorists? On the contrary, the court took for granted that if the Israeli and Palestinian communities are within close proximity of each other, and construction of the wall inevitably entails injury, it is the Palestinian side that must suffer. The majority of the fence route on the western side of the city runs on the Green Line, and part of it even within Israel. Even if true, it is irrelevant given that the ICJ ruling bore only on those parts of the wall situated within the occupied Palestinian territory. 258 Postscript. Tory, Advisory Opinion, Para 151, cf. The opinion's title, Legal Consequences of the Construction of a Wall in the Occupied Palestinian Territory. My emphasis. Likewise, the Trans-Israel Highway runs entirely inside the Green Line while the section of the wall interposed between the highway and Calcalia was built along the Green Line, which means that the ICJ decision doesn't bear on it. Since the fence around Calcalia was built, terrorist infiltrations in that area have ceased. Even if the efficacy of a wall for preventing terrorism is proven, in itself this doesn't demonstrate that the specific route chosen is the least injurious for achieving the stated objective, a wall built along the Green Line perhaps being equally effective. The court's complementary, and rhetorically most compelling, claim that segments of the wall encroaching on occupied Palestinian territory can be justified where, on the one hand, neither Palestinian communities nor agricultural lands are affected, while, on the other, the wall's route is dictated by a professional reason related to topography, the ability to control the immediate surroundings, and other similar military reasons is equally questionable. 34. The court never demonstrates that such deviations from the Green Line are based strictly on a professional reason, and are accordingly the least injurious route for the wall. Israeli reserve officers in the Council for Peace and Security, although supporting a wall to prevent terrorism, sharply disputed rationales for deviating from the Green Line such as topographical advantage, arguing that to route the wall on these grounds was not only superfluous but would in fact undermine Israeli security. HCJI Para 18. 35. The court peremptorily dismissed the Council's battery of arguments, however, in its absolute deference to the state. HCJI, Para 47. 36. The court also never explains the odd coincidence that, apart from a few kilometers of the wall located inside Israel, all the topographical advantages just happen to be on the Palestinian side of the Green Line, through which more than 80% of the wall runs. HCJ decision. Although it shall give the full appropriate weight to the norms of international law laid out in the ICJ decision, the High Court NDS that, because the factual basis of the ICJ advisory opinion was odd, Israel is not bound by its conclusions. The court RST retreads familiar ground on the military necessity of the wall and its route. Turning specifically to the Alphay Menashe enclave, the court said it reached the conclusion that the considerations behind the determined route are security, that it is not a political consideration which lies behind the fence route at the Alphay Menashe enclave, rather the need to protect the well-being and security of the Israelis, and, accordingly, that the decision to erect the separation fence at the Alphay Menashe enclave was made within the authority granted to the military commander. Para 101. The court next proceeds along the lines mapped in its RST decision of applying the proportionality test on a segment-by-segment basis. The segment under consideration in this second decision concerns an 11,000 dunam area incorporating Alphay Menashe, population 5,650, and VE Palestinian villages, total population 1,200. Located on the Israeli side of the wall, the enclave is territorially contiguous with Israel, Para 75. Applying the three-prong proportionality test, the court makes these determinations. The means used to achieve the stated objective must be rational or appropriate. The court reports petitioner's contention that the means used is irrational, whereas the stated objective is to prevent terrorism. The wall creates a reality, according to petitioners, in which hundreds of Palestinians end themselves west of the fence, without any checkpoint or gate between them and the cities of Israel. Therefore, it is difficult to see how the impingement upon the rights of the residents of the villages promotes the security of the State of Israel, of the IDF, or even of Alphay Menashe, none of which are separated from the residents of the villages, au contraire. The court peremptorily dismisses this contention, stating in full, "We cannot accept this argument. The separation fence creates a separation between terrorists and Israelis, in Israel and in the area, and from that standpoint, the required rational connection exists between the objective and the means for its attainment." Para 111. The means used to achieve the stated objective must be least injurious. The court reports the petitioner's contention that less injurious means could be used to achieve the security of Israelis by building the wall along the Green Line. Rejecting this claim, the court states, in their arguments before us, respondents the state correctly noted that construction of the separation fence on the Green Line would leave Alphay Menashe on the eastern side of the fence. It would be left vulnerable to terrorist attacks from Palestinians in the West Bank. Movement from it to Israel and back would be vulnerable to acts of terrorism. Indeed, any route of the fence must take into account the need to provide security for the 5,650 Israeli residents of Alphay Menashe. Para 112, 37. Nonetheless, the court does ND that a less injurious route, which protects the Alphay Menashe settlement yet leaves Palestinian villages outside the wall, is feasible. The alteration of the route, which will remove the villages from the enclave, will reduce the injury to the local residents to a large extent. Indeed, based upon the factual basis as presented to us, the existing route of the fence seems strange. We shall begin with the southwest part of the enclave. We are by no means convinced that there is a decisive security military reason for setting the fence route where it presently is. We shall now turn to the northern and northwestern part of the enclave. We were by no means convinced that it is necessary for security military reasons to preserve the northwest route of the enclave. Para 113. Thus, the court concludes, we have by no means been convinced that the second subtest of proportionality has been satisfied by the fence route creating the Alphay Menashe enclave, because an alternative route, which would ensure security with a lesser injury to the residents of the villages, is conceivable. Para 114. the damage caused by the means used to achieve the stated objective must be proportionate to the gain brought about by that means. The court NDS that, if the wall can be rerouted to exclude the Palestinian villages but still protect Al-Fay Menashe, the security of Israelis can be achieved without undue injury to Palestinians. In its null judgment, the court calls on the state to reconsider the various alternatives for the separation fence route at Al-Fay Menashe, while examining security alternatives which injure the fabric of life of the residents of the villages of the enclave to a lesser extent. Para 116. Appraisal. The court stated that it reached the conclusion that the wall's route creating the Al-Fay Menashe enclave was determined by military necessity. But although the court cited petitioners' arguments contesting this military necessity, 38 it never analyzed these counterclaims, explicating why they failed to convince. In addition, given the court's absolute deference to the state on military matters, it couldn't but have reached the conclusion of the state that the wall's route was based on security concerns. The court then proceeded to apply the three-prong proportionality test. In the means/ends test, it reported the petitioner's claim that the wall was irrational in view of the state's purported objective of averting terrorist attacks. The Al-Fay Menashe enclave being territorially contiguous with Israel allows hundreds of Palestinians living in villages alongside the Jewish settlement to enter Israel freely. Although the court itself acknowledged that the enclave is connected, with territorial integrity, to Israel, with no checkpoint, Para 9, it adduced no grounds for rejecting petitioner's argument, merely averring that the wall creates a separation between terrorists and Israelis, even if it manifestly didn't. 39. The court next applied the least injurious subtest. Significantly, in considering this subtest, the court explicitly acknowledged that the stakes in its current judgment were the protection of Jewish settlements in occupied Palestinian territory. 4. It didn't maintain, as before, that routing the wall along the Green Line was not an option on account of topography, etc., but rather that doing so would have left the Al-Fay Menashe settlement vulnerable to terrorist attack. In rejecting petitioners' claim that the wall could be routed along the Green Line, the court maintained that the settlers merited protection. It overlooked, however, the option of forcibly evacuating them. Indeed, it ignores two options less injurious of Palestinians while fully protecting settlers' rights as deemed by the court's own case law. Evacuating the settlers with compensation. At one point in the Al-Fay Menashe judgment, the court recalled the Gaza Coast Regional Council case, which upheld the state's right to evacuate the Gaza settlers. It cited from this case a central ending on the contingency of settlers' property rights. This property right is limited in scope. Most Israelis do not have ownership of the land on which they built their houses and businesses in the territory to be evacuated. They acquired their rights from the military commander, or from persons acting on his behalf. Neither the military commander nor those acting on his behalf are owners of the property, and they cannot transfer rights better than those they have. To the extent that the Israelis built their homes and assets on land which is not private land, state land, that land is not owned by the military commander. The State of Israel acts as the administrator of the state property and as usufructuary of it. The court went on to rule in the Gaza case that the state was even entitled to put a ceiling on the amount of compensation due settlers. In determining the substance of the impingement and the rate of compensation, one must take into consideration the fact that the rights impinged upon are the rights of Israelis in territory under belligerent occupation. The temporariness of the belligerent occupation affects the substance of the right impinged upon, and thus also, automatically, the compensation for the impingement. Para 22, apart from being perfectly legal on the High Court's own terms, the practical feasibility of compensating West Bank settlers while evacuating them was enhanced in light of, on the one hand, the expressed willingness of many settlers to voluntarily leave the occupied Palestinian territory in return for compensation and, on the other, the freeing up of probably billions of dollars for compensation that would otherwise have been squandered on the wall's construction. Ringing the settlements with electronic fences. Even if, in deons of international law, the court sought to protect the settlers while simultaneously enabling them to remain in situ, it still had an option less injurious to the Palestinian population. Even if Israel does not dismantle the settlements, Israeli human rights organization B'Tselem observes, the contention that the only option to defend the settlements is to situate them west of the barrier is baseless. Most of the settlements will remain east of the barrier. With the objective of protecting these settlements, the Ministry of Defense decided to erect a new protection system that includes an electronic fence to provide warning of infiltration, and a staff central control room, and to set up special security areas surrounding the settlements, where protection would be greater. These same measures can be taken for the settlements that, according to the current plan, will lie west of the barrier. Such action would provide a reasonable solution to the security threat they face and significantly reduce the infringement of the rights of the Palestinians that will occur if the barrier is erected on land within the West Bank. 41 In this regard, the court never explained the anomaly that if the state's purpose in constructing the wall was to protect settlers' lives, not to incorporate the major settlement blocks, and if the wall was the only means the state could devise to achieve this objective, then the state must have abandoned to a lethal fate the over 1,000 settlers left on the other side, whom it allegedly couldn't protect yet didn't even propose to evacuate. On a related point, in the case of some settlements, the state's decision to trace the wall's path, not leaving them outside, appears to have been dictated not by the strategic concern of annexing major blocks, let alone by security, but rather by the lobbying clout of local settler organizations. 42. The court did conclude, however, that the proposed route of the wall could not be justified on security military grounds, and recommended repositioning it to exclude Palestinian villages from the enclave. In fact, as Israeli human rights organizations have conclusively shown, the aim of the state's proposed route in Alfei Menashe, as elsewhere, was not security military but political, to facilitate massive settlement expansion. Had the purpose of the barrier been to protect the residents of Alfei Menashe, as Israel contends, and not to promote the expansion plans and to establish new settlements inside Alfei Menashe's jurisdictional area, the barrier could be built along the route of the fence surrounding the settlement. This option would still enable substantial growth of Alfei Menashe, for there is much land inside the fence available for construction. 43. A major problem arises, however, if not in the High Court's conclusion, then in its reasoning. The court earlier cited the state's contention that there is no justification for altering the Alfei Menashe route. The fence indeed changed the reality of life for the residents of the villages left on the Israeli side of the fence. This stems from the decisive security need to defend the citizens of Israel against terrorist attacks. The injury to the residents of the villages is proportionate, considering the decisive security need to leave the fence where it is, para 86, and the obstacle itself provides defense not only to the Alfei Menashe community itself, but also to the access roads and to its surroundings. However, the selected route is not the ideal route from a security standpoint. That is the case, due to the duty to protect the conflicting interests of the Palestinian residents, para 90. Thus, the state had testified that the route it proposed was both essential for Israel's security and least injurious to Palestinians, while still taking this essential Israeli security interest into account. For the court to cast doubt on these assertions, we are by no means convinced. We have by no means been convinced. It must have repudiated the tenet of its jurisprudence according to which the court does not substitute the discretion of the military commander with its own discretion, and does not examine the wisdom of the military commander's decision, but, rather, only render judgment on the legality of the military commander's recommendations, para 31. 44 Indeed, in challenging the state's right to decide on its own military necessity, the court demolished the basis of its own determination that the wall constituted a military necessity, which was reached only after absolutely deferring to the state's military authority. For security fence or permanent border. In its advisory opinion, the World Court affirmed the UN Charter's principle on the inadmissibility of acquiring territory by war and, accordingly, that Israel had no legal title to any of the West Bank, including East Jerusalem, which constitutes occupied Palestinian territory. Additionally, there is no dispute that under international law the occupying power must respect private property in occupied territory. Israel's High Court maintains that the wall's construction does not violate such strictures or, at any rate, the latter one, making no mention of the inadmissibility principle because Israel is only temporarily requisitioning Palestinian property for reasons of military necessity. It is worth noting, the court states in the second judgment, that construction of the separation fence is unrelated to expropriation or confiscation of land. The latter are prohibited by Regulation 46 of the Hague Regulations. Construction of the fence does not involve transfer of ownership of the land upon which it is built. The construction of the fence is done by way of taking possession. Taking of possession is temporary. The seizure order orders its date of termination. Para 16. And again, the fence is inherently temporary. The seizure orders issued in order to erect the fence are limited to a denied period of a few years, Para 100. 45. The court does, however, make eating reference to the fact that although seizure orders for Palestinian land are technically temporary, they are renewable, Para 39. It was just such inherently temporary seizure orders, initially issued and repeatedly renewed on grounds of security, that enabled the permanence of Israeli settlements in the occupied Palestinian territory. In the past, B'Tselem reports, Israel has used requisition for military needs orders as a means to take control of Palestinian land to establish settlements. These lands were never returned to their owners. It is now clear that Israel did not intend to seize the land for a temporary period, but to expropriate it permanently. 46. In light of this precedent, and combined with Israel's enormous financial investment in constructing the wall as well as its dismissal of alternative means for protecting Israel, and even the settlers in situ, it would seem arguable that the wall's primary purpose is not security and that Israel does not intend to return the land requisitioned for it but rather that Israel will establish a new, permanent border along the wall's sinuous route incorporating the great majority of the Israeli settlements under the pretext of military necessity. In its advisory opinion, the World Court voiced concern that the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent. Israel's High Court took note of this World Court concern but stated that the ICJ lacked a factual basis for reaching denied conclusions. 47. Not only the World Court, however, but human rights organizations as well have expressed such worries. B'Tselem concluded that the underlying reason of the wall's route is to establish facts on the ground that would perpetuate the existence of settlements and facilitate their future annexation into Israel. Likewise, Human Rights Watch concluded that the existing and planned route of the barrier appears to be designed to incorporate and make contiguous with Israel illegal civilian settlements. Likewise, Amnesty International concluded that Israel was building the wall to consolidate its control over land which is being used for illegal Israeli settlements, and that the very expensive and sophisticated structure of the fence/wall indicates that it is likely intended as a permanent structure. 48. Nonetheless, Israel's High Court averred that the fence is inherently temporary because the state said so. Soon after the court rendered its second judgment, however, the state publicly acknowledged that it had been disingenuous. The wall will serve as the future border of the State of Israel, then Justice Minister and current Foreign Minister Tzipi Livni stated, on December 1, 2005, and the High Court, in its rulings on the wall, is drawing the country's borders. Following this announcement, a High Court justice complained that this was not what the state contended in court. 49. Were it an independent judicial body and not a rubber stamp for the state, and were its deliberations designed to ferret out truth and not obfuscate it, the High Court would have discerned the wall's real purpose on its own long ago. You have to be nearly insane to think that somebody uprooted mountains, leveled hills, and poured billions here in order to build some temporary security barrier, journalist Meron Rappaport wrote in Yedioth Ahronoth. The moment the work began on the fence last August 2002, everyone understood that this was to be the new border. 50. Everyone, it seems, except the justices sitting on Israel's High Court. 51. In its July 2004 advisory opinion, the International Court of Justice found that the wall Israel was constructing in occupied Palestinian territory could not be justified on grounds of military necessity and that it violated absolute provisions of international law. The vote was 14-1, even the one judge casting a negative vote, Thomas Bjorgenthal, agreed that if the purpose of the wall was to protect Jewish settlements, it was ipso facto illegal under international law. Israel's High Court of Justice issued two major decisions on the wall. In the RST, rendered just prior to the ICJ advisory opinion, the High Court found that the wall was a military necessity to protect Israel from terrorist attacks, but that segments of it might inflict disproportionate harm on the local population and accordingly would have to be rerouted. The High Court concluded that the wall was a military necessity on the basis of the state's testimony, which the court held to be unimpeachable, despite compelling argumentation to the contrary. In applying a proportionality test to a segment of the wall, however, the court challenged the state's claim that the route chosen was necessary. In doing so, the court undercut its own ending on the wall's necessity, based as it was on absolute deference to the state. After the ICJ advisory opinion, the Israel High Court rendered a second decision bearing directly on the legality of building a wall to protect Jewish settlements. The court justified construction of a wall incorporating settlements on the grounds that it would protect the lives and safety of settlers. It ignored, however, that the settlers' lives and safety could be equally, and perhaps better, protected by repatriating them to Israel. The High Court also maintained that its disagreement with the ICJ related not to the normative legal framework but to the empirical facts surrounding the wall's construction. In fact, however, the High Court did not acknowledge bedrock principles of international law, principles which the ICJ emphasized: the inadmissibility of acquiring territory by war and the illegality of establishing settlements in occupied territory. These principles, not a dispute over empirical facts, proved to be dispositive in determining the wall's legality. Finally, the court upheld that, notwithstanding concerns registered by the ICJ and human rights organizations, and notwithstanding the weight of accumulated evidence, the wall was inherently temporary. Not long thereafter, the state acknowledged that the wall and the High Court's rulings on it were tracing Israel's future borders. The wall Israel has been constructing will annex to Israel some of the most productive West Bank land and water resources as well as East Jerusalem, the hub of Palestinian life. It will effectively sever the West Bank in two. The consensus of expert opinion is that it will preempt any possibility of a viable Palestinian state and, accordingly, of a just two-state settlement. 52. The consequence will be either the dismemberment of Palestine or endless bloodshed. The white glove of legality that the Israel High Court has drawn over this sanguinary process will be drenched in blood as well. Appendices. It is the job of the defense attorney, especially when representing the guilty, to prevent, by all lawful means, the whole truth from coming out. Alan M. Dershowitz, The Best Defense. 273. Next to Alan Dershowitz's egregious falsification of Israel's human rights record and the real suffering such falsification causes, Dershowitz's academic dereliction seems small beer. Yet he has written a book that purports to be an academic study, and its success is largely owing to Dershowitz's academic pedigree. His violations of elementary academic standards accordingly warrant exposure. In addition, they illustrate the complete absence of quality control when it comes to discourse on the Israel-Palestine conflict. Dershowitz can appropriate from a hoax with impunity due to an environment that tolerates such derelictions so long as the conclusions are politically correct. Some 20 years ago, one Joan Peters published From Time Immemorial, The Origins of the Arab-Jewish Conflict over Palestine. Although a national bestseller and critically acclaimed upon publication, the book was soon shown to be a hoax. Barak Kimmerling, of the Hebrew University, and Joel S. Migdal, in their authoritative study, Palestinians, The Making of a People, observe that Peters's book is based on materials out of context, and on distorted evidence. Citing this writer's own conclusion that the book is the most spectacular fraud. Appendix I. Of Crimes and Misdemeanors. Today I write nearly every day and publish a book almost every year. My test for publication is certainly not perfection. Alan M. Dershowitz, Letters to a Young Lawyer. Ever published on the Arab-Israeli Connect, they report that similar evaluations were expressed by notable historians in Israel and Europe. Returning to the case for Israel, we nd that the work relies heavily on either a single scholarly study by historian Benny Morris or pro-Israel websites and publications. The notable exceptions are chapters 1 and 2, which cite an impressive array of primary materials from 19th century Palestine, such as British consular reports. How did Dershowitz chance upon these recondite sources? Table AI. 1 juxtaposes the documentation in chapters 1 and 2 of the case for Israel 3 against the documentation in Peters's from time immemorial. Fully 22 of the FTY2 quotations and endnotes in chapters 1 and 2 of the case for Israel match almost exactly, including, in long quotes, the placement of ellipses those in from time immemorial. When evidence of his apparently unacknowledged lifting of Peters's research became public, Dershowitz vehemently denied any wrongdoing. He alleged both that this didn't constitute plagiarism and that it was proper to cite the primary sources rather than Peters on the ground that he independently consulted the primary sources. Leaving aside the highly dubious contention that another author's research can be claimed as one's own merely by virtue of checking that author's sources, did Dershowitz in fact check the originals before citing them? Consider a couple of examples from Table AI. 1. Young to Viscount Canning, January 13, 1842, row 7, quoting a statement depicting the miserable fate of Jews in mid-19th century Jerusalem, Peters cites a British consular letter from W. T. Young to Viscount Canning. Dershowitz cites the same statement as Peters, reporting that Young attributed the plight of the Jew in Jerusalem to pervasive anti-Semitism. It turns out, however, that the statement did not come from Young but, as is unmistakably clear to anyone who actually consulted the original, from an enclosed memorandum written by an A. Binnis, which Young was forwarding to Canning. Mark Twain, The Innocents Abroad, row 8, in his public defense Dershowitz was especially emphatic that he independently found the passages quoted from Twain, Crimson, September 30, 2003, The Nation, October 27, 2003. These passages are cited by Dershowitz from pages 349, 366, 375, and 441-42 of a 1996 edition of Twain's book. The same passages are cited by Peters from pages 349, 366, 375, and 441-42 of an 1881 edition of Twain's book. But the quoted passages do not appear on the pages of the 1996 edition cited by Dershowitz. Anyone who actually consulted the 1996 edition would have known this. In addition, Dershowitz cites 2 paragraphs from Twain as continuous text, just as Peters cites them as continuous text, but in Twain's book the 2 paragraphs are separated by 87 pages. It would have been impossible for anyone who actually checked the original source to make this error. Exhibit A, pages 244-45, below. Scrutiny of the advance uncorrected proofs of the case for Israel, 5, a copy of which was obtained by this writer from a correspondent, dispels any lingering doubts that Dershowitz lifted from Peters. Exhibit B, p. 246, below. Many of the footnotes in these proofs either are not yet LLED in or are in provisional form, and instructions are left for Dershowitz's research assistance on how to complete the text. Consider these examples from Table AI. 1. The footnote for the Twain quotes, row 8, in the proofs reads, The Creation of Yesterday, pages 159-60. The Creation of Yesterday is a section heading of From Time Immemorial, and the Twain quotes appear on the cited pages of that book. So much for Dershowitz having independently found them. The footnote for the cluster of testimonies regarding Palestine's population, row 15, in the proofs reads, Holly Beth, Cite sources on pages 160, 485, 486, FNS 141 to 145. Holly Beth Billington was one of Dershowitz's research assistants, credited on the acknowledgements page. Turning to these pages in from time immemorial, we nd the quotes and sources cited in the case for Israel. Exhibit C, p. 247, below. The footnote for the Zionist settlement, row 18, in the proofs reads, A. Druyanov site p. 527. The boldface is in the proofs. Exhibit D, p. 248, below. Turning to page 527 of From Time Immemorial, we nd the Druyanov citation. Notice, Nally, the wording in these examples. It doesn't say check sources on. Rather, it says cite sources on. Moreover, neither Joan Peters nor From Time Immemorial is even named. Dershowitz's assistants already knew exactly where to go. Beyond denying that he plagiarized From Time Immemorial, Dershowitz defended his reliance on Peters on the grounds that the case for Israel explicitly rejects her demographic conclusions. But does it? The central argument of From Time Immemorial was that Palestine was virtually empty on the eve of Zionist colonization. After Zionists made the desert bloom in the areas of Palestine they colonized, Arabs from other parts of Palestine and from neighboring Arab states settled in these areas to exploit new economic opportunities. It was these recent Arab arrivals, according to Peters, who left what became Israel during the 1948 war. The Arab refugees from that war, Peters concludes, weren't really refugees because they had only just settled there. As already. A. B. Exhibit A. Dershowitz quotes paragraphs from Twain as continuous text, A. Top, just as Peters quotes them as continuous text, B. Above. But in Twain's book, 1996 edition, which Dershowitz claims to have independently consulted, they are separated by 87 pages, see, opposite page. Notice also that in Dershowitz, just as in Peters, the last sentence of the RST paragraph reads, we never saw a human being on the whole route. The actual sentence in Twain continues, we never saw a human being on the whole route, much less lawless hordes of Bedouins. Mentioned, the scholarly consensus is that her demographic endings were sheer fraud. Palestine was underpopulated only by modern standards. Where rapid population growth is endemic, there is no evidence of any significant Arab internal migration in Palestine due to Zionist enterprise. There is no evidence of any significant Arab immigration into Palestine during the Ottoman or British Mandate period. Peters managed to prove her thesis only by mangling documents and falsifying numbers. 6. Returning to the case for Israel, Dershowitz writes that Palestine was vastly underpopulated when the Zionist settlers came, p. 23, while in a publicity interview for the book, he adly stated that almost nobody lived there. 7. So where did all those Arabs in the areas settled by Jews come from? According to Dershowitz, many of the Palestinian Muslims who were attracted to Western Palestine between 1882 and 1893 came from Eastern Palestine, the west and east banks of the Jordan, and the number of Muslims who lived in the Jewish areas grew dramatically after the Jewish settlements blossomed, p. 28. From these endings he reaches the inescapable conclusions, beyond reasonable dispute, that among the few Palestinian refugees who actually left more than half a century ago and who are still alive, many lived in Israel for only a few years, that an Arab was counted as a refugee if he moved just a few miles from one part of Palestine to another, even if he returned to the village in which he had previously lived and in which his family still lived, that the number of Palestinians with deep roots in the areas of Jewish settlement, although impossible to estimate with confidence, constitutes a tiny fraction of the more than 1 million Palestinian Arabs who now live in Israel, and that the myth of displacement by the European Jewish refugees of a large, stable, long-term Muslim population that had lived in that part of Palestine for centuries is demonstrably false. Pages 28, 86, 239, Dershowitz's emphasis. Does this sound like someone who fundamentally disagrees Forward, October 3, 2003, with Peters's fraudulent demographics? To prove the claim that those calling themselves Palestinian refugees had only recently settled in Palestine, Dershowitz provides this sensational piece of evidence: the United Nations, recognizing that many of the refugees had not lived for long in the villages they left, made a remarkable decision to change the definition of refugee only for purposes of denying who is an Arab refugee from Israel to include any Arab who had lived in Israel for 2 years before leaving. p. 86, Dershowitz's emphases. Yet the only source Dershowitz cites for this allegation, which he keeps repeating, pages 5, 87, 239, fails to support, or even imply, the claim that many refugees from the 1948 war had only recently settled in Palestine. 8. In fact, the import of the UN definition is exactly the reverse of what Dershowitz alleges. The definition reads: a Palestinian refugee is a person whose normal residence was Palestine for a minimum of 2 years preceding the conflict in 1948. Contrary to Dershowitz's insinuation, the purpose of this definition was to put a limit on who qualified as a Palestinian refugee, excluding seasonal workers from neighboring Arab states. 9. That Dershowitz should get things upside down won't, at this point, come as much of a surprise. What's more interesting is the real, unacknowledged source of his big ND. Turning to From Time Immemorial, we read this revelation of Peters. While I was examining United Nations data from 1948 onward, a seemingly casual alteration of the definition of what constitutes an Arab refugee from Israel caught my attention. In the case of the Arab refugees, the definition had been broadened to include as refugees any persons who had been in Palestine for only 2 years before Israel's statehood in 1948. p. 4, Peters's emphases. But, of course, Dershowitz did not in any way rely, p. 246 and 31, on Peters for his demographic argument. Dershowitz asserts that his detractors have failed to come up with a single example in which he directly cites from another source without attribution. Yet is this not an incontrovertible example that he has not only done so, but not less importantly in the process has presented demonstrably false statements from a discredited book? Finally, in a genuine tour de force, he even manages to out-falsify Peters. For instance, to document that even many Arab intellectuals acknowledge the mythical nature of an indigenous Palestinian Arab population, Dershowitz cites the statement of Palestinian leader Musa al-Omma from Peters: the people are in great need of a myth to lull their consciousness and imagination, p. 28. Not even Peters pretends, however, that al-Omma meant in the statement that Palestinians had fabricated their place of origin, compare Peters, pages 13 to 14. Dershowitz just made it up. Amid these falsifications from N. of Peters, he deplores the mendacious rewriting of the demographic history of the Arabs of Palestine to deny Jewish rights there, and admonishes those who play games with the demographics in order to support agenda-driven conclusions, pages 7, 68. To defend himself against the allegation that he lifted from Peters, Dershowitz resorted to other means as well. He claimed that he experts I consulted real experts, with vast experience and no ideological axe to grind, know of no case in which a student or faculty member was ever disciplined for doing what I did. The Nation, December 15, 2003. The one and only expert he named, however, is James Friedman, former president of Dartmouth College and of the American Academy of Arts and Sciences. No doubt his are impressive credentials, although Friedman might have made a more compelling independent witness if he weren't, as the Boston Globe reports, one of Dershowitz's closest confidants, Dershai, as Friedman calls his old friend Alan Dershowitz, if he weren't an apologist for Israel, even lobbying Brandeis University, where he is a trustee, to grant Ariel Sharon an honorary degree, for his humanitarian work, and if he didn't mangle the Chicago Manual of Styles meaning when citing it in Dershowitz's defense. 10. Faced with some of the derelictions in the case for Israel, one doesn't know whether to laugh or cry. The book was published in August 2003. Footnote citations date from as late as June 2003, which means that work on the manuscript continued until shortly before publication. By Dershowitz's own admission, The Case for Israel is not a scholarly tome replete with minutiae, but rather a work of advocacy organized into 32 very short, simple chapters. In September 2003, just 1 month after the book's publication, this writer debated Dershowitz on Amy Goodman's nationally syndicated program Democracy Now! The debate was in 2 parts, only one of which has been broadcast. In the RST part, Dershowitz's misattribution of the locution "turn speak" came up. This is a verbatim transcription of the segment. Finkelstein, in Joan Peters's book From Time Immemorial, she coins a phrase. The phrase is "turn speak." 11. And she says Dershowitz, and she borrows it from Finkelstein. No, Dershowitz, she borrows it Finkelstein, Sir Dershowitz, from, who is it? Finkelstein, sir, I'm sorry Dershowitz, oh, she attributes it and borrows it. Finkelstein, sir, I'm sorry. Dershowitz, from someone else. It's not her phrase. Finkelstein, she coins the phrase. You see, you don't know what you're talking about, and that's pretty terrible. Dershowitz, it's not her phrase. Finkelstein, she coins a phrase "turn speak," and she says that she is using it as a play off of George Orwell, who, as all listeners know, used the phrase "newspeak." Dershowitz, right. Finkelstein, and she coined her own phrase "turn speak." You go to Mr. Dershowitz's book, he got so confused in his massive borrowings from Joan Peters, that on 2 occasions, I'll cite them for those who have a copy of the book, on page 57, and on page 153 he uses the phrase quote George Orwell's "turn speak." Dershowitz, Finkelstein, "turn speak" is not Orwell, Mr. Dershowitz. You're the Felix Frankfurter Chair at Harvard. Dershowitz, yes. Finkelstein, you must know that Orwell would never use such a clunky phrase as "turn speak." Dershowitz, I like it. I think it's a hell of a phrase. Finkelstein, well, maybe you might like it. Dershowitz, I do. Finkelstein, and evidently Joan Peters liked it, but George Orwell never heard of it. The point is not simply that The Case for Israel confounds Peters with Orwell. Look closely at the phrases of Dershowitz placed in italics. He did not even know to whom the locution "turn speak" was repeatedly ascribed in The Case for Israel. Exhibit E, opposite. He did not even know Orwell. It couldn't be that he forgot a name from his research, unlikely as that would anyhow be just a month after the book's publication and regarding a name highlighted on more than one occasion in the book. An author might forget a more or less obscure name cited from the source material, but how likely is it that an author would forget a prominent name error of his or her own creation? Someone repeatedly writing in a book Aristotle's Schism, would almost certainly remember associating Schism with Aristotle. How did Dershowitz not remember Orwell? Were this not perplexing enough, in an otherwise minatory letter addressed to New Press when it was considering publication of Beyond Chutzpah, Dershowitz conceded. Exhibit E. From, who is it? I did, mistakenly believe that the word "turn speak" had come from Huxley. I confused "turn speak" with "newspeak." Underscore is Dershowitz's, 12. From Huxley? Leaving aside that Dershowitz has now managed the trifecta blunder of confusing Peters with Orwell and Orwell with Aldous Huxley, 13. It seems he hasn't a clue of his book's content. Alan Dershowitz lifted material from a hoax in a book that has become an influential bestseller. To date, Dershowitz's employers and colleagues have either remained silent or rallied behind him. A spokesman for Dean Elena Kagan of Harvard Law School reported in December 2004 that former Harvard President Derek Bok, a scholar of unquestioned integrity, had looked into the charges against Dershowitz and found that no plagiarism had occurred. The matter was closed. 14. Yet what is one to make of the evidence assembled in this appendix? Harvard University's own manual states that plagiarism is passing off a source's information, ideas, or words as your own by omitting to cite them. Writing with Sources, A Guide for Harvard Students, 1995, Section 3.1. The same source also states that when quoting or citing a passage you found quoted or cited by another scholar, and you haven't actually read the original source, cite the passage as quoted in or cited in that scholar, both to credit that person for finding the quoted passage or cited text, and to protect yourself in case he or she has misquoted or misrepresented. Ibid. Section 2.1. The unambiguous evidence in this appendix shows that Dershowitz directly appropriates a crucial idea from Peters which he keeps repeating and which is demonstrably false without referencing her. Equally to the point, Kagan and others who have risen to Dershowitz's defense have without exception done so on the basis of his insistence that he consulted the original text cited in the case for Israel. Yet not one of them has refuted the overwhelming evidence in this appendix, perhaps unavailable to them, that Dershowitz in fact repeatedly copied information directly from Peters's book. History of the Israel-Palestine Conflict. Defense lawyers often develop what I call DLBS, defense lawyer's blind spot. They refuse to see the evidence of their client's guilt, even when it is staring them in the eye. Alan M. Dershowitz, Letters to a Young Lawyer. Mufti Machinations. In the case for Israel, Alan Dershowitz devotes many pages to the Mufti of Jerusalem, Haj Amin al-Husseini, who led the Palestinian national movement during the British Mandate years. It is well known that the Mufti personally collaborated with the Nazis. However, Dershowitz makes many claims beyond this fact. On pages 54 to 60, he writes, "The SS, under the leadership of Heinrich Himmler, provided both financial and logistical support for anti-Semitic pogroms in Palestine. Adolf Eichmann visited Husseini in Palestine and subsequently maintained regular contact with him. The official leader of the Palestinians, Haj Amin al-Husseini, was taken on a tour of Auschwitz by Himmler. The Mufti was apparently planning to return to Palestine in the event of a German victory and to construct a death camp modeled after Auschwitz, near Nablus. In 1944, a German Arab commando unit under Husseini's command parachuted into Palestine in an effort to poison Tel Aviv's wells. It is fair to conclude that the official leader of the Muslims in Palestine, Haj Amin al-Husseini, was a full-edged Nazi war criminal, and he was so declared at Nuremberg. The Grand Mufti of Jerusalem was personally responsible for the concentration camp slaughter of thousands of Jews. Some Arab and Palestinian leaders bore significant responsibility for the Holocaust. Most of these allegations are taken, if not always with proper attribution, from an unsourced opinion column in a right-wing Israeli newspaper. Sarah Honig, Fiendish Hypocrisy 2, The Man from Klopstock St., Jerusalem Post, April 6, 2001. 1. The claim that the Nazis financed the 1936–1939 Arab Revolt is credited by Dershowitz to Benny Morris's righteous victims, but there isn't any mention of this on the cited pages or any others in Morris's study. 2. It can be found, however, in Honig's column. What does the scholarly literature report about the Honig-Dershowitz claims? None of the major academic treatments of the Arab Revolt, for example, the Palestinian Arab National Movement by Israeli historian Yehoshua Porath, or the Palestinian People by Israeli professor Barak Kimmerling and University of Washington professor Joel S. Migdal mention Nazi funding. 3. The major biographies of the Mufti are the Mufti of Jerusalem by Palestinian historian Philip Matter and the Grand Mufti by Israeli historians V. L. Peleg. Neither of these sources mentions Husseini accompanying Himmler to Auschwitz. Neither of these sources mentions a Husseini plan to build an Auschwitz-style camp in Nablus. Neither mentions a German Arab commando unit en route to poison Tel Aviv's wells. Neither mentions that Husseini was indicted at Nuremberg. His name is not even listed in the index to the proceedings of the Nuremberg Tribunal. It is correct that Husseini petitioned the Nazis during the final solution not to allow Jews, including Jewish children, to enter Palestine. It is unknown, however, whether his intercession had any practical impact. Matter found no hard evidence that it did, while Elpeleg concluded that it is impossible to estimate the extent of the consequences of Hajamin's efforts. Dershowitz cites Elpeleg's book but not this conclusion. Raoul Hilberg, the dean of Nazi Holocaust scholars, believes it unlikely that the Mufti's pleas had any influence. No scholar affirmatively maintains that Husseini was personally responsible for the concentration camp slaughter of thousands of Jews or bore significant responsibility for the Holocaust. Hilberg devotes all of one sentence to Husseini's role in his monumental, 3-volume study of the Nazi Holocaust. 4. Finally, Dershowitz is curiously silent on another initiative emanating from Palestine to collaborate with Hitler. Beginning in late 1940, the dissident right-wing Zionist organization IZL in Israel sought an agreement with the Nazis on the basis of a collusion of interests between the New Germany and the reborn Völkische Nationalen Hebräertum, and for the purpose of the re-establishment of the Jewish state in its historic borders, on a national and totalitarian basis, allied with the German Reich. Although the Nazis proved unresponsive notwithstanding repeated appeals, this Zionist initiative did have one noteworthy denouement. A member of this group of would-be Nazi collaborators, Yitzhak Shamir, went on to become the Prime Minister of Israel. 5. Appendix 3. Peace process. We do have a license to advocate outcomes, which we know would be objectively unjust but subjectively beneficial to our clients. Alan M. Dershowitz, Letters to a Young Lawyer. In 1983, Noam Chomsky published The Fateful Triangle, the United States, Israel, and the Palestinians. Apart from exhaustive research bringing to light a documentary record little known in the United States, the main innovation of the book was to recast debate on resolving the Israel-Palestine conflict. Until then, the terms of debate in the United States typically juxtaposed the Arab against the Israeli position. Chomsky coined the term international consensus to denote a third pole in the debate, the settlement favored by the international community. Registered in numerous forums, most notably, United Nations resolutions, this international consensus supported a two-state settlement incorporating the provisions of UN Resolution 242, Israeli withdrawal from the West Bank and Gaza, on the one hand, and Arab recognition of Israel's right to live in security, on the other, as well as establishment of a Palestinian state. Chomsky's main empirical insight, copiously documented, was that the Palestinian leadership and key Arab states had come around to supporting the international consensus for a two-state settlement, whereas Israel and the United States were the major, indeed, before long, the only opponents of it. Whereas Chomsky had previously given support to a binational state along the lines advocated before Israel was founded, he aligned himself from after the October 1973 war with the international consensus on the grounds that, although far from ideal, it was the only practical basis for a settlement that provided a modicum of justice for all parties concerned. In Fateful Triangle he wrote, within the international consensus, there has been little discussion of whether such a settlement henceforth, a two-state settlement, wreaks higher demands of abstract justice. Rather, it has been taken to be a politically realistic solution that would maximize the chances for peace and security for the inhabitants of the former Palestine, for the region, and for the world, and that satisfies the valid claims of the two major parties as well as is possible under existing conditions. One can imagine various subsequent developments through peaceful means and mutual consent towards a form of federation or other arrangements. 3. While sentiment in Chomsky's political milieu has, in recent years, been shifting toward a one-state solution incorporating Israel and the occupied territories, he himself hasn't deviated from support of the two-state settlement in his extensive writings and lectures on this topic since publication of Fateful Triangle. In the case for Israel, Alan Dershowitz states that the premise of this book is a two-state solution, P2. This premise is repeatedly anchored by Dershowitz in what he refers to as the international consensus or worldwide consensus favoring such a settlement, pages 64, 65, 69, CFP3. Yet, while using Chomsky's framework and even his coinage, Dershowitz brazenly asserts, in the face of a 3-decade-long written record proving otherwise, that Chomsky rejects the two-state solution, P3. 4. As against Chomsky, Dershowitz proclaims that I've always favored a two-state solution. 5. This will certainly be news to those who followed Dershowitz's pronouncements over the years. There is no record of him ever having supported an independent Palestinian state or criticizing Israel's opposition to it. In the early 1990s, Dershowitz advocated not an independent Palestinian state but some form of autonomy for Palestinians. 6. Indeed, in his 1991 autobiography, Dershowitz expressed some doubt whether Israel should in any way mitigate its military occupation. I think, though I am not certain, that Israel is making a mistake in continuing to occupy heavily populated Arab areas on the West Bank and in Gaza. But the decision to exchange lawfully captured territory, even heavily populated territory, for the promise of peace, even if such a promise were forthcoming, is so complex, so fraught with risk, so unprecedented in world history, so involved with domestic political considerations and consequences, that I, for one, am reluctant to participate in the cacophonous chorus of know-it-all criticism that is currently directed at Israel for its inaction. 7. In a recent Haaretz interview, Dershowitz gave this account of his past views: I always thought that Israel made a terrible mistake by not accepting the Allon plan. Israel made a mistake by not making unilateral border adjustments after the war in the spirit of Security Council Resolution 242. Israel and the UN made a mistake in 1967 by not understanding that there is a difference between occupying land and occupying people. Occupying land is okay. Territorial changes after a war of defense are any, especially in the case of Jordan, which started the war against Israel in 1967. Whoever starts a war should take into consideration that it may suffer territorial changes. On the other hand, occupation of people is always bad. I was always against occupation of people, but not against occupation of land. 8. The Allon Plan, proposed soon after the June 1967 war by senior Labour Party official Yigal Allon, called for Israel's annexation of up to half the West Bank, with the fragmented areas of dense Arab settlement exercising in lieu of statehood some form of autonomy or link with Jordan. 9. Contrariwise, the international consensus has called for Israel's full withdrawal to its pre-June 1967 border and the establishment of an independent Palestinian state in the West Bank and Gaza. But unlike Chomsky, Dershowitz has always favored a two-state solution based on the international consensus, even if his own written record shows contrariwise. On pages 238 to 39 of the Case for Israel, Alan Dershowitz refers to the so-called Palestinian right of return and claimed right to return, and states that the time has come, indeed the time is long overdue, to put an end to this right of return charade by so-called Arab refugees. In December 1948, the United Nations General Assembly affirmed, in accordance with the Universal Declaration of Human Rights, UDHR, the right of Palestinians driven into exile during the Arab-Israel War to return home. 1. Paragraph 11 of General Assembly Resolution 194, 3, resolves that the refugees wishing to return to their homes and live at peace with their neighbors should be permitted to do so at the earliest practicable date, and that compensation should be paid for the property of those choosing not to return. 2. The principles of this resolution go as part of the international consensus among states and human rights organizations for resolving the Israel-Palestine conflict. General Assembly resolutions noting with regret that repatriation or compensation of the refugees, as provided for in paragraph 11 of its Resolution 194, 3, has not yet been effected, and requesting continued efforts towards the implementation of that paragraph were adopted by votes of 151 to 2, Israel, Marshall Islands, in December 2001, 158 to 1, Israel, in December 2002, and 167 to 1, Israel, in December 2003. 3. A December 2003 General Assembly resolution that stresses the need for resolving the problem of the Palestine refugees in conformity with its Resolution 194, 3, passed 160 to 6, Israel, United States, Palau, Uganda, Micronesia, Marshall Islands. 4. All emphases in originals. In December 2000, Human Rights Watch, HRW, sent open letters to President Clinton, Prime Minister Barak, and President Arafat regarding the Palestinian refugees. They uniformly stated, "Since the inception of the international refugee system FTY years ago, 3 durable solutions have emerged under international law and refugee policy to enable refugees to put an end to their refugee status and re-establish an effective link with the state. These include voluntary repatriation to the refugee's country of origin, local integration in the country of asylum, or resettlement in a third country." HRW calls on Israel, a future Palestinian state, countries currently hosting stateless Palestinians, and the international community to ensure that individual refugees are able to make free and informed choices for themselves from among these 3 established precedents. To this end, HRW urges Israel to recognize the right to return for those Palestinians, and their descendants, who fled from territory that is now within the State of Israel, and who have maintained appropriate links with that territory. This is a right that persists even when sovereignty over the territory is contested or has changed hands. If a former home no longer exists or is occupied by an innocent third party, return should be permitted to the vicinity of the former home. As in the cases of all displaced people, those unable to return to a former home because it is occupied or has been destroyed, or those who have lost property, are entitled to compensation. However, compensation is not a substitute for the right to return to the vicinity of a former home, should that be one's choice. And again, neither the options of local integration and third country resettlement, nor their absence, should extinguish the right to return. Their humanitarian purpose is to allow individual Palestinians to select during a specified period among several choices for ending their refugee status. In a separate statement, HRW noted that it had likewise defended the right of refugees to return to their homes in Bosnia, Chile, China, East Timor, Rwanda, and Guatemala, as well as in other instances. 5. In March 2001, Amnesty International released a policy statement regarding the Palestinian refugees. It stated, "Amnesty International calls for Palestinians who or were expelled from Israel, the West Bank or Gaza Strip, along with those of their descendants who have maintained genuine links with the area, to be able to exercise their right to return. Palestinians who were expelled from what is now Israel, and then from the West Bank or Gaza Strip, may be able to show that they have genuine links to both places. If so, they should be free to choose between returning to Israel, the West Bank or Gaza Strip. Palestinians who have genuine links to Israel, the West Bank or Gaza Strip, but who are currently living in other host states, may also have genuine links to their host state. This should not diminish or reduce their right to return to Israel, the West Bank or Gaza Strip. However, not all Palestinian exiles will want to return to their own country, and those who wish to remain in their host countries or in the West Bank or Gaza Strip should be offered the option of full local integration. The international community should also make available to Palestinian exiles the option of third country resettlement. Whatever solution the individuals choose should be entirely voluntary, and under no circumstances should they be coerced into making a particular choice. Where possible, Palestinians should be able to return to their original home or lands. If this is not possible because they no longer exist, have been converted to other uses, or because of a valid competing claim, they should be allowed to return to the vicinity of their original home. Palestinians who choose not to exercise their right to return should receive compensation for lost property, in accordance with principles of international law. Those returning should likewise be compensated for any lost property. Amnesty pointed out that it has similarly supported the right to return of people from countries in all regions of the world, including Bhutan, Bosnia-Herzegovina, Croatia, East Timor, El Salvador, Guatemala, Kosovo, and Rwanda. 6. On page 143 of the Case for Israel, Alan Dershowitz writes, Palestinian terrorists have lynched and blown up more people, including hundreds of people of color, than the Ku Klux Klan managed to kill in its century-long reign of terror. The corresponding endnote reports, some of the 27 Marines killed by Palestinian terrorists in Beirut were black, p. 252, chapter 20 N5. Leaving aside the sheer weirdness of attempting to prove that Palestinians have killed more people of color than the Ku Klux Klan, and leaving aside that it was 241, not 273, American servicemen, mostly Marines, who were killed in the October 1983 suicide bombing, there isn't a jot of evidence, not even serious speculation, that Palestinians were in any way involved. 1. On page 37 of the Case for Israel, Alan Dershowitz writes, many of the Jews who lived in what became Transjordan, some of whom had lived there for generations, had been forced to leave because of episodic outbreaks of violence and, by law, the few remaining Jews were forbidden from living in Transjordan. The corresponding endnote reads, Jordanian Nationality Law, Article 3 of Law No. 6, and Official Gazette, No. 1171, February 16, 1954, p. 247, Chapter 4 and 13. On the one hand, carefully compiled Ottoman population statistics do not show any Jews having lived in the area that became Transjordan during the preceding century. 2. On the other hand, the Jordanian nationality law cited by Dershowitz does not address the citizenship status of indigenous Transjordanian Jews at all. According to Article 3, any non-Jewish person who possessed Palestinian citizenship prior to May 15, 1948 and was normally resident within the Hashemite Kingdom of Jordan on the date this law was issued, February 16, 1954, is considered a Jordanian citizen. 3. As is immediately obvious, the purpose of the law is to regulate the status of former Arab citizens of Palestine who had become resident in Jordanian-controlled territory as a result of the 1948 war, i.e., West Bankers and refugees, rather than to deprive Jews who were already Jordanian citizens of their existing rights. Furthermore, the law excludes only those Jews who were both Palestinian citizens prior to 1948 and resident in Jordan in 1954, and then only from the opportunity of automatic naturalization, hardly a natural right. The remainder of the 1954 citizenship law underscores the reality that Article 3 excluded only a specific group of Jews rather than all Jews, and that it was drafted in the context of Jordanian absorption of the West Bank and Palestinian refugees at a time when Jordan and Israel were still formally at war. Indeed, no other article of the citizenship law regulating naturalization explicitly excludes Jews. 1. Strange, Day in September. On page 257 and 21 of the Case for Israel, Alan Dershowitz reports, estimates vary as to the number of Palestinians killed during Black September, with some estimates as high as 4,000, 1 day in September. Sony Pictures, www.sonypictures.com/classics/onady/html/blackcpt, last visited April 10, 2003, while others cite the Gur of 3,000. Some key dates in the Israeli-Palestinian conflict, www.umich.edu/IINetKmanaz/study unit/Israeli-Palestinian_conic/student keydates.html, last visited April 10, 2003. In September 1970, King Hussein of Jordan brutally suppressed a Palestinian insurgency. The range Dershowitz cites for Palestinian deaths during the Black September massacre is accurate. Oddly, however, his RST source is the publicity website for a 1999 movie called 1 Day in September, while the second is a chronology appended to a high school syllabus. When this writer publicly noted the anomaly of a chair at Harvard Law School using such references, Dershowitz explained to the Boston Globe, "I'm happy that I don't have to cite inaccessible sources." 1. It gets curiouser and curiouser, however. Although citing a range of 3,000 to 4,000 Palestinian deaths during Black September in the case for Israel, Dershowitz reports in Why Terrorism Works that as many as 20,000 Palestinians were killed in Black September. 2. In September 1972 at the Munich Olympics, 8 Palestinians belonging to a faction called Black September killed 2 members of the Israeli team and took 9 others hostage. During a botched rescue operation by Bavarian police, all the Israeli hostages and VE of the 8 Palestinian attackers were killed. 3 of the Palestinians were injured, captured, and held for trial. On pages 43 to 44 of Why Terrorism Works, Dershowitz makes this sensational claim. Less than 2 months after the Olympic murders, Chancellor Willy Brandt made a secret deal with the Palestinian terrorists. Together they arranged for other Palestinian terrorists to hijack a Lufthansa plane from Beirut carrying 11 German men and a skeleton crew and to hold these Germans hostage, threatening to kill them unless the 3 Munich murderers were owned to freedom in an Arab country. Feigning terror at the prospect of Germans being murdered on a Lufthansa plane, Brandt gave in to the demands of these terrorists. Many observers suspected that the Lufthansa hijacking had been staged by the Brandt government to concoct an excuse for releasing the 3 terrorists, as a way of avoiding a real hijacking. Until recently there was no proof of this cynical secret deal between the government that had botched the rescue of the Israeli Olympic team and the terrorists who had murdered the Israelis, but it has now been confirmed by both Palestinian and German sources that the Lufthansa hijacking was a sham and that the Germans were all too eager to free the murderers. This time Dershowitz's source is not the movie One Day in September but a subsequent book based on it. His endnote refers readers to Simon Reeve, One Day in September, New York, 2000, p. 158, citing Jamal al-Gashey, one of the terrorists responsible for the Munich massacre, and Ulrich Wagner, the founder of the elite German anti-terrorist unit GSG-9, p. 59. 3. The pseudonym al-Gashey is given to one of the 3 imprisoned Palestinians later freed whom Reeve claims to have tracked down. One problem with relying on books based on movies is that they aren't always the most reliable sources. Typically Dershowitz gets the basic facts wrong. For example, the 11 passengers weren't all German but overwhelmingly non-German, including an American. 4. The United States would later criticize Brandt for having released the Palestinians, but during the hijacking the U.S. ambassador to Germany pressed the German government to acquiesce in the hijackers' demands in order to save the American hostage. 5. Regarding the 2 personal testimonies to the alleged Brandt plot, Reeve conceals the whereabouts and even physical identity of the pseudonymous al-Gashey, while there's reason to suppose that Israel long ago liquidated all 3 Palestinians freed after the Munich massacre and that, therefore, he doesn't exist. 6. Wagner has asserted that my statement in the LM One Day in September can't be interpreted as evidence for an alleged secret deal between the federal government and terrorists, emphasis in original. 7. Every member at every level of the German government contacted. From surviving senior officials of the Brandt government to the German Foreign Office and the Chancellery, dismisses the Reeve claim as preposterous, as do all knowledgeable German journalists and scholars, Jewish and non-Jewish alike. 8. But, basing himself on one book, which is itself based on a movie basing itself on 2 highly dubious sources, Dershowitz tells readers that this sensational tale has now been confirmed. Finally, in a model of situational ethics, while he castigates for an American audience Brandt's capitulation to Palestinian terrorists, Dershowitz tells the German newspaper Die Welt, there are of course some German people who are deserving of much respect, Willy Brandt, for example. 9. On pages 54 to 55 of Why Terrorism Works, 1. Alan Dershowitz writes, the UN General Assembly even went so far as to encourage Palestinian terrorism directed against Israeli and Jewish civilians. In 1979, it approved an exception to the International Convention against the Taking of Hostages. The amendment, which was expressly intended to permit hostage-taking by Palestinians, went as follows: the present convention shall not apply to an act of hostage-taking committed in the course of armed conflicts, in which people are acting against colonial occupation and alien occupation and against racist regimes in the exercise of their right of self-determination. This formulation then became part of several anti-terrorist resolutions, all of which implicitly exempted acts of terrorism committed by Palestinians against Israelis and Jews. Emphasis in original. The United Nations General Assembly raided the International Convention against the Taking of Hostages on December 17, 1979, RES 34/146. There are several problems with Dershowitz's claim that it encourages Palestinian terrorism. On a smaller, technical point, the passage he cites isn't an amendment but comes right from Article 12 of the Hostage Convention. The larger, substantive point is that he has grossly misrepresented Article 12, the full text of which reads, "Insofar as the Geneva Conventions of 1949 for the protection of war victims or the additional protocols to those conventions are applicable to a particular act of hostage-taking, and insofar as states parties to this convention are bound under those conventions to prosecute or hand over the hostage-taker, the present convention shall not apply to an act of hostage-taking committed in the course of armed conflicts as deemed in the Geneva Conventions of 1949 and the protocols thereto, including armed conflicts mentioned in Article 1, Paragraph 4, of Additional Protocol I of 1977, in which peoples are acting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. As enshrined in the Charter of the United Nations and the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations. This article takes note that prohibitions against hostage-taking in the context of armed conflict, including armed conflicts in which peoples are acting, in the exercise of their right of self-determination, already exist. Additional Protocol I explicitly extends the meaning of armed conflicts in the Geneva Conventions and accordingly the absolute ban on hostage-taking to conflicts arising in the course of a people's exercise of its right to self-determination. The plain intent of the Hostage Convention was extending yet further the prohibition against hostage-taking, beyond the context of armed conflicts, not to diminish existing sanctions against it. Lest there be any doubt regarding Dershowitz's mangling of the text, the voting record at the General Assembly dispels it. Israel and the United States approved the Hostage Convention. 2. To judge by Dershowitz, they both voted to encourage Palestinian terrorism directed against Israeli and Jewish civilians. 2. For the voting record, see http://untreaty.un.org/english/status/chapter_18/treaty5.asp. Israel affirmed the applicability of the Convention's prohibition on hostage-taking in all circumstances, while the United States approved without comment. This writer is indebted to Rafal Zacharovsky for clarifying these points. 363. In June 2007, DePaul University denied tenure to N Finkelstein, an assistant professor of political science. The decision ignited a storm of protest from DePaul students and faculty, as well as from faculty across the country and abroad. Finkelstein's department had voted 9-3 in favor of tenure, and a college-level committee unanimously joined that recommendation, 5-0. But the University Board on Promotion and Tenure, UBPT, voted 4-3 against tenure, and DePaul's president claimed to no compelling reasons to overturn the UBPT's decision. The tenure denial was a great victory for Harvard Law School's Professor Alan Dershowitz, who had been campaigning vigorously against Finkelstein at least since the fall of 2006. Their feud began when Finkelstein charged that Dershowitz's book The Case for Israel, 2003, was partially plagiarized and wholly false. Finkelstein ultimately published his critique as part of a book of his own, entitled Beyond Chutzpah, on the Misuse of Anti-Semitism and the Abuse of History, 2005. The book quotes Dershowitz as offering, in an interview, to give $10,000 to the PLO if anyone can and a historical fact in the case for Israel that you can prove to be false, p. 91. 1. Finkelstein maintains, to the contrary, that the genuine challenge is to unearth any meaningful historical fact in the case for Israel, p. 91. Finkelstein goes on to quote one assertion after another from the case for Israel, examine Dershowitz's supporting evidence, and then adduce his own evidence that the assertions are false and Dershowitz's evidence worthless. Dershowitz has not taken these charges lightly. In June 2006, the former chairman of Finkelstein's department wrote to Dershowitz about his charges that Finkelstein is guilty of various forms of intellectual dishonesty, asking Dershowitz to direct him to the clearest and most egregious instances of dishonesty on Finkelstein's part. Dershowitz responded in a 7-page, single-spaced letter dated September 18, 2006, and he enclosed 14 single-spaced pages of supporting materials. Dershowitz sent a similar but even longer packet of materials totaling over 60 pages to a large but unknown number of members of DePaul's faculty and administration, including every professor at the law school. Dershowitz began his September 2006 letter, hereafter the letter, by stating that the ugly and false assertions that I will discuss below are not incidental to Finkelstein's purported scholarship, they are his purported scholarship. Finkelstein's entire literary catalogue is one preposterous and discredited ad hominem attack after another. Dershowitz went on to list a number of alleged lies or fabrications by Finkelstein. He also provided a link to an online copy of Chapter 16 of his book The Case for Peace, 2005. 3. That chapter, entitled A Case Study in Hate and Intimidation, hereafter case study, dealt exclusively with Finkelstein's critique of the case for Israel. The news media's coverage of the dispute has not included any serious attempt at evaluating the merits of Dershowitz's and Finkelstein's charges and countercharges. It's clear enough that these guys don't like or respect each other, and that each claims the other's work is a travesty. But the question remains, who's right and who's wrong? In this essay I attempt to provide an answer. I also present compelling evidence that Dershowitz himself committed academic misconduct both before and in the course of his intervention in Finkelstein's tenure case. I conclude with some reactions on the ramifications of my analysis for both DePaul and Harvard. 4. Beyond Chutzpah purports to refute virtually every aspect of the case for Israel's account of Israel's human rights record and the history of the Israel/Palestine conflict. Consequently, the most striking feature of Dershowitz's letter is that not one of the numbered items in the letter is taken from Beyond Chutzpah. The introduction to the letter does, however, contain one charge against Beyond Chutzpah. Here is the background. In a column published in the Jerusalem Post, March 11, 2002, Dershowitz proposed that Israel should retaliate for each Palestinian terrorist attack by engaging in the destruction of a small village which has been used as a base for terrorist operations. The residents would be given 24 hours to leave, and then troops will come in and bulldoze all of the buildings. He added that the destruction of the village will be automatic. The order will have been given in advance of the terrorist attacks and there will be no discretion. 5. In his book Why Terrorism Works, which was published a few months after the Jerusalem Post column, September 4, 2002, Dershowitz referred to the policy he proposed in March 2002 and cited his Jerusalem Post column. But in his book Dershowitz described the Jerusalem Post policy inaccurately, saying that his proposal was for Israel to respond to Palestinian attacks by destroying empty houses in a particular village that has been used as a base for terrorists. 6. He also said that here is something seriously troubling, of course, about the bulldozing of an entire village, even if its residents have been evacuated, though he claimed such a policy would be just nonetheless, p. 177. The Jerusalem Post column, however, said nothing about evacuating anyone. Rather, it proposed that the village's residents be given 24 hours notice and that the destruction of the village at the end of the notice period be automatic. It also said nothing about refraining from destroying the village, or any part of it, if some or all of its residents failed or were unable to leave. Indeed, Dershowitz's Jerusalem Post proposal excluded the possibility of exercising such restraint, because the destruction of the village was to be automatic and leave no room for discretion. In Beyond Chutzpah, Finkelstein wrote that Dershowitz advocates not only individual house demolitions but also the destruction of a small village which has been used as a base for terrorist operations after each Palestinian attack. The response will be automatic. Such massive destruction, he concludes, will further the noble causes of reducing terrorism and promoting peace. It is hard to make out any difference between the policy Dershowitz advocates and the Nazi destruction of Lidice, a Czech village destroyed by the Nazis in retaliation for the assassination of a Nazi officer, for which he expresses abhorrence, except that Jews, not Germans, would be implementing it. Pages 175 to 76. Finkelstein cited Dershowitz's Jerusalem Post column as his source for the quotations concerning the automatic destruction of entire villages, p. 175, n. 19. I have checked the quotations myself, and they are accurate. That's the background. Now the charge. In his letter, Dershowitz criticized Finkelstein for his oft-made sick claim, found on page 176 of Beyond Chutzpah, that it is hard to make out any difference between the policy Dershowitz advocates and the Nazi destruction of Lidice, for which he expresses abhorrence, except that Jews, not Germans, would be implementing it. The trouble is that the policy and passage Finkelstein quotes actually says, Israel would then publicly declare precisely how it will respond in the event of another terrorist act, such as by destroying empty houses in a particular village that has been used as a base for terrorists, and naming that village in advance. In Finkelstein's world, destroying empty houses in order to deter terrorism is the equivalent of genocide. Emphasis added. Dershowitz developed the same argument at greater length in the packet of materials he sent to DePaul's faculty and administration. Dershowitz's quotation concerning destroying empty houses, however, comes from his book Why Terrorism Works and does not appear in his Jerusalem Post column. It is therefore not true that the policy and passage Finkelstein quotes actually says what Dershowitz claimed it says. Finkelstein accurately quoted the policy and passage from the Jerusalem Post column, which proposed the destruction of entire villages and said nothing about destroying only empty houses, and he cited the Jerusalem Post as his source for the quotation. The language Finkelstein quoted does not appear in Why Terrorism Works. It is consequently unmistakable that Finkelstein was quoting, and comparing to Lidice, the Jerusalem Post proposal concerning the destruction of entire villages, not the Why Terrorism Works proposal concerning the destruction of only empty houses. The problem here is not merely that Dershowitz is wrong. Everyone makes mistakes. Rather, his charge seems to be an instance of academic misconduct, because there is no way he could have honestly, but mistakenly, believed Finkelstein was quoting, and comparing to Lidice, the Why Terrorism Works proposal concerning empty houses, rather than the Jerusalem Post proposal concerning entire villages. Because Dershowitz purported to be correcting the record concerning the policy and passage Finkelstein quotes, he must have looked at Finkelstein's citation to see what source Finkelstein was quoting. And finding that Finkelstein was quoting the Jerusalem Post, Dershowitz quoted an alternative passage from Why Terrorism Works and claimed, falsely, that that's what the passage Finkelstein quoted really said. That is not a mistake. It appears to be a deliberate misrepresentation. It also bears emphasis that this misrepresentation appears in the fourth paragraph of Dershowitz's 4,000-word letter. Thus, even readers who lack the patience to read the whole letter, or who might be inclined to dismiss Dershowitz as biased, would likely be misled. Any reader who assumed that Dershowitz would not brazenly misrepresent the contents of his own or Finkelstein's writings would be left thinking, well, that is pretty bad. Finkelstein accused Dershowitz of proposing the destruction of entire villages, when Dershowitz was talking only about empty houses. 368. If this was not an honest mistake by Dershowitz, but rather a deliberate misrepresentation, then it would seem to constitute academic misconduct. It would be a deliberate attempt to deceive the DePaul faculty concerning the merits of a pending tenure case. In addition, when considered in light of the evidence, Dershowitz's concluding sentence in Finkelstein's world, destroying empty houses in order to deter terrorism is the equivalent of genocide, reveals itself to be false 2 times over. First, Finkelstein did not say that destroying empty houses is similar to the Nazis' destruction of Lidice. Rather, he said that destroying an entire village, which Dershowitz proposed in the Jerusalem Post, is similar to the Nazis' destruction of Lidice. Second, Finkelstein did not say that either of Dershowitz's proposals, destroying entire villages or destroying empty houses, is the equivalent of genocide. Rather, he said that one of Dershowitz's proposals, the destruction of entire villages, appears to be indistinguishable from the Nazis' destruction of literacy. The destruction of literacy was not, by itself, genocide, and Finkelstein never said it was. Because I have no independent expertise on Nazi war crimes in general or the destruction of literacy in particular, I will not offer an opinion on Finkelstein's claim that the destruction of literacy is similar to Dershowitz's Jerusalem Post proposal. It should be noted, however, that Dershowitz himself has not denied their similarity. Beyond Chutzpah. No other charges appearing anywhere in Dershowitz's letter are directed against Beyond Chutzpah. In the case study, Dershowitz's examples of Finkelstein's alleged pattern of macking up quotations and facts, p. 185, are likewise not drawn from Beyond Chutzpah, but there is a straightforward explanation. Both the Case for Peace, which contains the case study, and Beyond Chutzpah were published in August 2005, so it was impossible for either book to contain a response to the other. But when Dershowitz wrote his letter to the former chair of Finkelstein's department in the fall of 2006, he had ample time to identify any instances of dishonesty in Beyond Chutzpah. Still, apart from the one charge already discussed, the letter mentions none. Some of Dershowitz's examples in his letter do, however, relate to Beyond Chutzpah. Here's the background for the main example. In the case for Israel, Dershowitz lamented that Israel's methods of interrogating Palestinian prisoners had been universally characterized as torture, even though they were non-lethal and did not involve the infliction of sustained pain. 7. The endnote to that sentence reads as follows. One person died following shaking, but an independent investigation attributed his death to an unknown pre-existing medical condition, p. 252, n9. As support for those claims, the endnote cites a single decision of Israel's Supreme Court. In Beyond Chutzpah, p. 160, Finkelstein quoted the endnote verbatim and then attempted to refute it. Against Dershowitz's claim that there had been only one interrogation-related death, Finkelstein quoted the reports of two independent human rights organizations, both of which concluded that there have been several such deaths, pages 160-61. And against Dershowitz's claim that the one prisoner who died following shaking actually died because of a pre-existing medical condition, Finkelstein quoted Amnesty International's report on that prisoner, entitled Death by Shaking, the case of Abd al-Samad Harazat. According to Finkelstein, Amnesty reported that Israeli officials originally attributed the death to a pre-existing medical condition, but it so happened that Abd al-Samad Harazat was in good health at the time of his sudden death, p. 161. The Amnesty report further stated that the official autopsy, which was conducted by two Israeli doctors and observed by a Scottish doctor on behalf of the decedent's family, concluded that Harazat died because of violent shaking. According to Amnesty, the Department of Investigations of Police reached the same conclusion, as did both an expert opinion on the official autopsy report and a statement from the Israeli Ministry of Justice. Finkelstein then wrote the following, pages 161-62. The Supreme Court decision cited by Dershowitz, HCJ 5100/94, states that ALL agree that Harazat expired after being shaken. The court decision makes no mention of an independent investigation attributing Harazat's death to an unknown pre-existing medical condition. Indeed, no record of this independent investigation exists. That's the background. What did Dershowitz have to say in response? In his letter, Dershowitz wrote, "Here is what Finkelstein said in Chicago on March 18, 2004, there was a famous case in 1995 of a Palestinian who was shaken to death while in detention. And nobody disputed the facts. The Israeli pathologist's office, the forensic pathologists who were brought into the case, eventually it went to the Israeli High Court of Justice. They all agreed. And I'm quoting now from the High Court of Justice judgment, all agree that Harazat died from the shaking." If you go to Dershowitz's book, he discusses the case and says, quote, An independent inquiry found that he didn't die from the shaking, but from a previous illness. That was just made up. It was Finkelstein who made up the quotation. The Supreme Court actually said that the suspect expired after being shaken. The difference between died from the shaking and expired after being shaken is considerable, especially since the sentence that follows in the decision attributes the death to an extremely rare complication, and the sentence before summarizes the literature as having no examples of anyone dying from shaking. This is not a translation error. It is an example of a made-up quotation. Remember, Finkelstein said he was quoting, not paraphrasing, yet the words he purports to quote simply do not exist. Finkelstein has never, to my knowledge, responded to the serious charge of fabricating a quotation from the Israeli Supreme Court. Finkelstein's pattern of making up quotations should alone disqualify him from any tenured academic position. Because Dershowitz cited no book or other publication, I will assume that he was quoting an interview or lecture that Finkelstein gave in Chicago on March 18, 2004. I will also assume that he was quoting Finkelstein accurately. Dershowitz made essentially the same argument in his case study, p. 185, though there he quoted from a Finkelstein appearance on C-SPAN 2, p. 233, and 118. What should we make of this exchange? On the one hand, in Beyond Chutzpah Finkelstein, 1, accurately quoted both Dershowitz and the Supreme Court decision, 2, adduced evidence refuting Dershowitz's claim that there has been only one Palestinian death from interrogation, 3, asserted that the Supreme Court decision cited by Dershowitz made no reference to any independent investigation that concluded Harazitz's death was not caused by shaking, 4, cited multiple independent investigations that did attribute the death to shaking, and 5, asserted that there is no record of an independent investigation that reached a contrary conclusion. On the other hand, in his letter Dershowitz, 1, ignored what Finkelstein wrote in Beyond Chutzpah, 2, quoted some oral presentations in which Finkelstein inaccurately quoted two passages that he later quoted accurately in Beyond Chutzpah, and 3, charged Finkelstein with having made up the quotation s. Dershowitz never responded to, let alone refuted, any of Finkelstein's substantive claims in Beyond Chutzpah concerning the number of interrogation deaths, the actual independent investigations of Harazitz's death, or the fact that Dershowitz's cited source does not mention an independent investigation that attributed the death to a pre-existing medical condition. Thus, continuing to assume that Dershowitz accurately quoted Finkelstein, we can draw the following conclusions. Finkelstein appears to have made two inaccurate oral quotations of material he quoted correctly in Beyond Chutzpah. Dershowitz's The Case for Israel appears to contain multiple serious inaccuracies concerning Israel's violent interrogation of Palestinian prisoners. Moreover, in the case study, Dershowitz attempted to conceal the inaccuracies in the case for Israel by misrepresenting both his own endnote and the Supreme Court opinion that he cited in it. Dershowitz wrote, p. 234, and 120. What the High Court said was that medical literature has not, to date, reported a case in which a person died as the direct result of having been shaken. It did reference a case, different from the one I discussed in my book, in which the suspect expired after being shaken, but explained that according to the state, that case was a rare exception, where death was caused by an extremely rare complication which resulted in pulmonary edema, emphasis added. In addition, Finkelstein misquotes me as saying he didn't die from the shaking. I actually said, one person died following shaking, and he knows I was discussing a different case. Dershowitz thus claimed that the case in which, according to the Supreme Court, the suspect expired after being shaken was not the same case Dershowitz discussed in the case for Israel. That cannot be true. The endnote in the case for Israel refers to only one person who died following shaking. Dershowitz mentioned that one person as the one potential exception to his claim that Israel's interrogation methods are non-lethal. The only source Dershowitz has ever cited concerning that one person is the Supreme Court opinion. But the Supreme Court opinion mentions only one case of a person dying after shaking, so they must be the same case. It should also be noted that in this endnote from the case study, Dershowitz largely admitted that the case for Israel's reference to an independent investigation was incorrect. Recall that, in the case for Israel, Dershowitz cited the Supreme Court opinion as his only source concerning the independent investigation that found the death was caused by an unrelated medical condition. In the case study endnote, however, Dershowitz acknowledged that the Supreme Court did not assert in its own voice that Harazitz's death was caused by an extremely rare complication. The court did mention that assertion. But the court neither endorsed it nor attributed it to an independent investigation. Rather, as quoted by Dershowitz, the court said that according to the state, the death was caused by an extremely rare complication. That is, the assertion that Harazitz's death was caused by a rare complication was made by the Israeli government lawyers who were defending the security services' interrogation methods. The court's opinion states no basis for the lawyer's assertion. For all the court tells us, the lawyers might have just made it up. Dershowitz's letter contains no other items related to Beyond Chutzpah. It mentions the plagiarism issue, which I address below, but the letter states that Dershowitz is not answering that charge here. But his case study does contain two others, p. 185. Dershowitz wrote that Finkelstein claims that in the case for Israel I never once, I mean literally, not once mention at any mainstream human rights organization. Never a mention of Amnesty's endings, never a mention of Human Rights Watch's endings, never a mention of B'Tselem's endings. None. But a simple check of the index reveals that I repeatedly discuss and criticize the endings of these very organizations. Dershowitz again cited the C-SPAN 2 appearance as his source for the quotation, p. 233, N 117. Again, I will assume he quoted it accurately. Here is what Finkelstein wrote in Beyond Chutzpah, p. 92. The most fundamental and telling fact about the chapters of the case for Israel devoted to human rights issues is that never once does Dershowitz cite a single mainstream human rights organization to support any of his claims. Not only does Dershowitz systematically ignore their endings, but in order to justify having done so, he seeks to malign the human rights organizations themselves. Finkelstein then went on to discuss some of the case for Israel's criticism of human rights organizations such as Amnesty International and B'Tselem, an Israeli organization monitoring human rights violations in the occupied territories, p. 93. Again, what should we make of this exchange? On the one hand, in Beyond Chutzpah Finkelstein pointed out that Dershowitz, in the case for Israel, purported to defend Israel's human rights record but never once cited a mainstream human rights organization in order to support his claims. Rather, Dershowitz cited such organizations only to discredit them. On the other hand, Dershowitz, 1, quoted an incorrect oral statement by Finkelstein to the effect that the case for Israel never cited mainstream human rights organizations at all. 2, pointed out that the case for Israel does indeed cite mainstream human rights organizations, in order to discredit them, and 3, charged Finkelstein with macking up facts. Again, Finkelstein appears to have made a fairly trivial oral misstatement. Dershowitz, however, appears to have implicitly admitted that he did precisely what Beyond Chutzpah charged him with doing. The case for Israel, his best-selling defense of Israel's human rights record, cites mainstream human rights organizations only to discredit them, never for support. The case study contains one other charge relating to Beyond Chutzpah. Background: Dershowitz wrote in his book Chutzpah, concerning the plight of the Arab Palestinians who were expelled in 1948, that the expulsion is a FTH rate issue analogous in many respects to some massive urban renewal or other projects that require large-scale movement of people. 8. In Beyond Chutzpah, Finkelstein accurately quoted part of that statement. He omitted "or other projects that require large-scale movement of people," p. 47. A few pages later, he cited several prominent Israeli scholars, Barak Kimmerling, Elon Papp, and Benny Morris, as having described the 1948 expulsion as an ethnic cleansing, p. 53, and 29. In the case study, Dershowitz wrote the following. Another made-up quotation by Finkelstein is his claim that in my book Chutzpah I analogized ethnic cleansings to urban renewal. I say nothing of the kind in Chutzpah. I never even mention ethnic cleansing, p. 185. As his source, Dershowitz cited a talk by Finkelstein at the Vancouver Public Library in 2004, p. 234, N 121. It is true that the relevant passage in Chutzpah does not employ the phrase ethnic cleansing. It is also true that in Chutzpah Dershowitz drew an analogy between urban renewal and the 1948 expulsion of the Arab Palestinians, which, according to Finkelstein, has been described by prominent Israeli scholars as ethnic cleansing. In his letter, Dershowitz did not challenge Finkelstein's claim about what the Israeli scholars say, so I have not independently verified it. I also have not checked the accuracy of Dershowitz's quotation from Finkelstein's appearance at the Vancouver Public Library. But it should be noted that it is not clear from Dershowitz's own rendering of the quotation that Finkelstein ever attributed the phrase ethnic cleansing to Dershowitz. That's it. Apart from the plagiarism issue, nothing else in either the letter or the case study, or elsewhere in the case for peace, relates to Beyond Chutzpah. Skeptical readers may wonder whether Dershowitz's charges could really be this silly and inconsequential. Such readers should not take my word for it. The letter is available on Finkelstein's website, and it contains a link to an online copy of the case study. The texts of the case for Israel, the case for peace, Chutzpah, and Beyond Chutzpah, including endnotes, are also searchable online at Amazon.com. Not all pages are viewable online, but many of the relevant ones are. Recall now that in Beyond Chutzpah Finkelstein quoted and purported to refute claim after claim after claim from the case for Israel. Recall also that 1 year later, in his letter listing the clearest and most egregious instances of Finkelstein's dishonesty, Dershowitz's sole attempt to refute any of the claims in Beyond Chutzpah, plagiarism aside, appears to have been based on a deliberate misrepresentation of what Finkelstein wrote. And note that the foregoing discussion seems to tell us something about just how clear and egregious some of the instances in the letter are. From these facts it appears reasonable to conclude that, with the possible exception of the plagiarism issue, Dershowitz has been unable to ND a single false statement in Beyond Chutzpah. And it follows that, as far as Dershowitz himself can now determine, his own book The Case for Israel is full of falsehoods concerning Israel's human rights record and the history of the Israel/Palestine conflict, while Finkelstein's book contains none. Conspiracy theories. Although published at the same time as Beyond Chutzpah, the case study constitutes Dershowitz's most thorough discussion of Finkelstein's assault on the case for Israel. The thesis of the case study is that Finkelstein's attack was the product of a well-orchestrated campaign devised by a left-wing anti-Israel conspiracy whose members are Noam Chomsky, Alexander Cockburn, and Finkelstein. The chapter opens with an introductory description of the conspiracy, pages 167 to 70. Next come subsections consisting of attacks on each of the alleged conspirators, pages 170 to 72 Chomsky, pages 172 to 75 Finkelstein, p. 175 Cockburn. The next subsection describes the conspiracy's previous work, including its campaign to discredit Joan Peters's From Time Immemorial, 1984, the book Finkelstein accused Dershowitz of plagiarizing, pages 175 to 80. Finally, in the last subsection of the chapter, Dershowitz turns to the conspiracy's attacks against him, pages 180 to 88. The bulk of his discussion, however, either deals exclusively with the plagiarism charge, pages 180 to 84, or describes the power and extensive influence of the conspiracy, pages 186 to 88. E.g., Finkelstein can get anything he writes published, regardless of its demonstrable falsehoods, because Noam Chomsky has enormous influence on the hard left press. Beyond Chutzpah was in fact published by the University of California Press after undergoing a rigorous peer review process. Apart from the plagiarism issue, just one page of the 22-page chapter is devoted to arguing that some of Finkelstein's claims about Dershowitz are false, p. 185. That one page contains, by my count, VE separate charges against Finkelstein. I have already dealt with 3 of them: shaking, citation of human rights organizations, and ethnic cleansing, in the previous section. The remaining 2 do not require extensive discussion. One is based on a quote for which Dershowitz cited no source, so it can fairly be ignored. The other involves a quote from a talk Finkelstein gave in Calgary in 2004. According to Dershowitz, Finkelstein has even alleged that the autobiographical account of my life in Chutzpah 1991 growing up as an Orthodox Jew in Brooklyn in the 1940s and 1950s does not have much to do with what has actually happened in my life, p. 185, alterations by Dershowitz. I have not checked the accuracy of the quote because I cannot imagine why anyone would care enough to debate it. Apart from that one page, plus the plagiarism issue, Dershowitz's arguments in his case study suffer from the well-known defect inherent in all ad hominem arguments: they attack the messenger but leave the message untouched. That is, it does not matter whether Dershowitz's conspiracy theory is true. Even if it were true, that would not show that any of Beyond Chutzpah's claims about the case for Israel, and about Dershowitz's other writings, are false. Because Dershowitz's conspiracy theory thus has no bearing on the merits of the dispute between Finkelstein and Dershowitz, I will not discuss it further. Plagiarism, the big picture. When Finkelstein RST attacked the case for Israel in a debate with Dershowitz on the radio program Democracy Now! In 2003, one of his principal charges was that Dershowitz had plagiarized significant portions of his book from Peters's From Time Immemorial. Finkelstein has not dropped that charge, but he has repeatedly stated that it is of SEC. Andre importance, the main issue being the truth about Israel's human rights record. In Beyond Chutzpah, he relegated the discussion of the issue to one of the book's 3 appendices, introducing it with the observation that, next to Dershowitz's alleged whitewash of Israel's human rights record, Dershowitz's academic dereliction seems small beer, p. 273, 229. In the Democracy Now! Debate, Finkelstein also charged that Dershowitz did not write the case for Israel himself. Dershowitz claims he can prove he wrote it, because he is still in possession of his own handwritten manuscript for the book, Case Study, p. 181. Finkelstein informs me that he requested a copy of that manuscript, but Dershowitz refused to provide it. In any event, Finkelstein did not include the charge in Beyond Chutzpah. I therefore will not discuss it further. Some background on Peters's book is needed to ground an assessment of the plagiarism controversy. From Time Immemorial argues that at the time of Israel's founding in 1948, many of the Arab inhabitants of the areas that became the State of Israel were actually recent immigrants. They and their ancestors had not lived there from time immemorial. When the book was originally published in the United States in 1984, it received glowing reviews in periodicals across the country and quickly became a bestseller. Later, when a number of scholars, of whom Finkelstein was the first, examined the book carefully, they concluded that it was of no scholarly value whatsoever. It ignored important parts of the documentary record, misused the sources on which it did rely, and contained straightforward logical errors. Consequently, Peters's book has been rejected as worthless by the scholarly community in Israel and around the world. Skeptical readers should not take my word for it. Yehoshua Porath, one of Israel's leading scholars on the Arab population of Palestine during the pre-state period, described the book as a sheer forgery, adding that in Israel, at least, the book was almost universally dismissed as sheer rubbish except maybe as a propaganda weapon. New York Times, November 28, 1985. Porath, who describes his own politics as centrist, also tore the book to shreds in a review published in the New York Review of Books, January 16, 1986. The review is freely available online, together with a subsequent exchange of letters that is also quite illuminating. March 27, 1986. Given the well-known scholarly repudiation of Peters's book, no scholar would rely on it, any more than a scholar would rely on the protocols of the elders of Zion. Now, back to the plagiarism issue. Finkelstein argued that in the RST2 chapters of the Case for Israel, Dershowitz appropriated Peters's work by lifting numerous quotations and citations directly from Peters's book without acknowledging that he found them there. Beyond Chutzpah, p. 274, 230. Dershowitz countered that although he was led to some primary sources by seeing them cited in Peters's book, he always tried to check them before citing them. If he could not nd the primary source himself, he cited Peters. If he was able to check the primary source, he cited it directly, without mentioning Peters. He claimed that his failure to cite Peters in such circumstances is proper. Case study, p. 182. Finkelstein's principal response was that Dershowitz's quotations and citations of primary sources, where Dershowitz does not cite Peters, contain obvious errors that Dershowitz could not have made if he had checked the primary sources himself, and that Dershowitz's errors are identical to Peters's errors concerning the same primary sources. Beyond Chutzpah, pages 274-75, 230-31. Finkelstein inferred that Dershowitz copied the quotations and citations from Peters rather than checking the primary sources himself. Dershowitz has never, to my knowledge, responded to this argument. He has not argued, for example, that the alleged errors do not exist, or that his errors are not identical to Peters's, or that the identical errors are just a coincidence and are easy to make even when one checks the primary sources. In the next section I present what I consider to be overwhelming evidence that Finkelstein's argument is sound. But I wish to emphasize that the entire plagiarism issue seems to me to be of relatively little importance. If Dershowitz had uncovered a little-known but true and important piece of scholarship on the Middle East and had plagiarized it, passing off the original author's work as his own, he would surely have been guilty of a serious breach of academic integrity and would have done an injustice to the original author, who would have been deprived of deserved credit. At the same time, however, Dershowitz would have been doing a substantial public service by bringing the original author's true and important insights to a much wider audience than they had previously received. If that were what he had done, on balance I would probably be glad he had done it. But that is not what he did. Instead, he relied upon a best-selling book that has been condemned by the international scholarly community. Even if his citations to Peters were impeccable, even if he is right that they are in fact impeccable, it is still true that he repackaged material from Peters's discredited bestseller, from time immemorial, and added to it his own imprimatur, as a Harvard law professor, in his bestseller The Case for Israel. On this issue, Dershowitz has only two potential lines of defense. He could argue that he did not really rely on Peters's book in The Case for Israel, or he could argue that, contrary to the international scholarly consensus, Peters's book really is a legitimate source on which a serious scholar can reasonably rely. To some extent, Dershowitz has pursued both defenses. In The Case for Israel, for example, Dershowitz wrote that Peters's conclusions and data have been challenged. I do not in any way rely on them in this book, p. 246, and 31. Likewise, in his case study, Dershowitz wrote, I disagreed with some of Peters's conclusions and said so in my book The Case for Israel, pages 175-76. As proof that he had said he disagreed with some of her conclusions, Dershowitz noted that in The Case for Israel he wrote, Palestine was certainly not a land empty of all people. It is impossible to reconstruct the demographics of the area with any precision, since census data for that time period are not reliable. The Case for Peace, p. 229, and 60, quoting The Case for Israel, p. 24. The quote does not mention Peters, so it is not in fact an example of Dershowitz having said that he disagreed with Peters's conclusions. Moreover, to my knowledge not even Peters ever claimed that Palestine was a land empty of all people before Zionist immigration. Despite Dershowitz's attempts to distance himself from certain aspects of Peters's book, the fact remains that by his own admission, case study, p. 182, he relied upon Peters at least for some primary sources that he was unable to locate himself. Given the scholarly consensus concerning Peters's book, no serious scholar would have done that. As regards the legitimacy of relying on Peters, Dershowitz wrote in his case study that, although from time immemorial has its ahs, it was supported by evidence and contributed an important new element to the debate, p. 176. To support that claim he cited reviews of Peters's book that appeared in the Washington Post in 1984 and the Financial Times in 1985, p. 229, and 61. Regardless of what those reviews do or don't prove about Peters's contribution to scholarly debate in the mid-1980s, they prove nothing about whether Peters's book was considered a reputable scholarly source in 2003, when Dershowitz published The Case for Israel. Dershowitz further stated that N Finkelstein managed to show was that in a relatively small number of instances, Peters may have misinterpreted some data, ignored counterdata, and exaggerated some endings. Common problems in demographic research that often appear in anti-Israel books as well, including those of Chomsky, case study, p. 177. He cited no authority for that assessment, and he never set forth or engaged with Finkelstein's arguments in detail. Readers who are curious about Finkelstein's critique of Peters can and it in his Image and Reality of the Israel/Palestine Conflict, 2nd ed. 2003, and judge for themselves. I take it that Dershowitz has not succeeded in refuting the international scholarly consensus that from time immemorial is neither a serious piece of scholarship nor a source on which a serious scholar would reasonably rely. Moreover, Dershowitz's weak disclaimers, e.g., that certain aspects of Peters's book have been challenged and that the book suffers from common problems in demographic research, actually make matters worse. They create the misleading impression that the book's ahs are common in other reputable works in the ELD and that the book is merely the subject of scholarly controversy. It is not. Serious scholars no longer debate Peters's book, they dismiss it. There is consequently no way out for Dershowitz here. Either he knew that Peters's book was discredited or he didn't. If he did know it, then he intentionally used a thoroughly disreputable source. If he didn't know it, then he was too ignorant of mainstream scholarly work on Israel/Palestine to deserve to be taken seriously. Either way, by relying on Peters in the case for Israel and expressly defending her in the case for peace, he took himself outside the realm of serious, informed discussion of the topic on which he was writing. Plagiarism, the evidence. I now turn to a detailed evaluation of Finkelstein's argument concerning allegedly identical errors in the case for Israel and from time immemorial. I have examined the texts relevant to one of the quotations implicated in Finkelstein's argument, and I see no reasonable alternative to the conclusion that the argument is sound. Dershowitz must have copied the quotation from Peters, not from the original source. The quotation is from Mark Twain's The Innocents Abroad, see Beyond Chutzpah, p. 275, 231. It appears on pages 23 to 24 of the Case for Israel and pages 159 to 60 of From Time Immemorial. Dershowitz's version of the quotation omits two of the sentences that Peters's version includes. Dershowitz also omitted Peters's italics and added a few errors that Peters did not make. Apart from those discrepancies, Peters's and Dershowitz's versions of the quotation are identical, character for character. I have checked Peters's and Dershowitz's versions of the quotation against the 1996 Oxford University Press edition of The Innocents Abroad, which is the edition Dershowitz cited. Peters's version contains many errors, and Dershowitz's version reproduces every one of them. The errors are summarized in the accompanying table.